We permitted to mention a matter, my lord, on 8th of August, at the instance of the husband, petitioner, my lord, the lordship was pleased to direct the learned trial to dispose of the matrimonial suit. And on that, in this application, my lord, you'll have to ask the learned advocate for the opposite petitioner that whether in the section 24 is pending before that court, which said that if nothing is pending, he's paying everything. Well, it transpired, well, I'm for the wife that section 24 is pending and the order was on the suppression of the material fact matter, the section 24 is pending. Therefore, my lord, I filed an application under for modification of the lawsuit order, my lord. Kindly, the trial court has fixed the date on 8th and the court is proceeding with the kindly 8th. Kindly direct the, my lord, the matter to appear tomorrow, my lord, so that
tomorrow
My lord,
হেডে একদম উপরে দিয়ে দেবে টু মেনশনের পরেই
my lord, may I have your lordship kind indulgence? My lord, one listed motion, my lord. My lord, land is used by the government.
Motion, please hand over the slip.
There is urgency, my lord.
But yesterday I mentioned the matter. Your lordship was pleased to give direction, my lord, to serve a notice upon the
Yes.
learned advocate, my
Who
lord.
is appearing?
My lord, Shantimay Bhattacharya.
Yes.
Let the matter tomorrow, my lord.
He hand over the slip. Have you mentioned the urgency?
No.
Please mention the urgency, hand over.
Listed matter, my lord. Item number.
Please mention the urgency, hand over the slip.
May I have your lordship's kind leave to mention. I mentioned this matter yesterday. Your lordship directed me to give notice to upon all these parties. Pursuant to such notice, what I'm mentioning further, this is appearing as item number 361 of the monthly list. But the urgency is that I have challenged the tender process. And there was a specific direction from the Honorable Court on the last occasion that the respondent shall file a report, which they have not filed till date.
Who is appearing for the other side?
I am for the corporation. In the meantime, also the successful LOI has been issued in favor of the successful bidder. The petitioner in his writ petition has not disclosed his eligibility, but he annexed the eligibility criteria of the other participants. So we have obtained that the criteria that the petitioner, since he has not fulfilled the eligibility criteria, we have asked for the document in order to substantiate that he was an eligible candidate.
He was not eligible.
No. That's why his tender was not accepted.
We have not received till date any kind of notice.
Lordship, kindly takes up the matter.
Have you implemented the successful tenderer?
They say right now, they didn't disclose on the earlier occasion.
No, Lordship, the matter was moved on 26th of September.
Portal also that they have
and on 8th of
the name of the successful bidder.
On 8th of October.
Let that come in the public domain. I will take appropriate steps.
Have you filed any application?
Or they are disclosing right now, Lordship, for the very first time without any documents, without anything being disclosed in the public domain. Let them disclose it in the public domain. I shall make appropriate application.
Kalke diye din.
Lordship, we shall submit the particulars of the.
Let them file the report. There was a specific direction.
For the file.
Thereafter, I will consider whether to be implemented or not.
Yes, kindly
please file it. Kalke to be mentioned. Yes,
I'm grateful to you, Lord.
My lord, may I be permitted to mention a matter for inclusion under heading 4 orders, my lord. My lord, Justice Aniruddha Rai passed an order on 8th January 2025. The matter is pending since 2023, my lord.
For orders, I have to hear it afresh. Cannot be.
Then, my lord, any other subsequent
report was directed to be filed.
No, my lord. Nothing as such, my lord.
Why it was for orders?
My lord, on joint prayer of the parties, the writ petition, sir.
On the joint prayer for orders, how can it be?
Appear under heading.
Maybe some other orders were passed prior to that. Please look the other orders, then mention. Yes.
May I have your lordship's kind leave to mention a matter for non-prosecution? It is a Group 1 land matter.
Group 1?
Group 1 land matter.
To be mentioned non-prosecution. Have you mentioned their non-prosecution? Yes.
Lordship, 104 of your lordship's monthly list. Lordship, I had mentioned it yesterday, and lordship directed me to serve and come back. Lordship, I have served and come back. This
you indicated the urgency.
Yes, lordship, but there is a little bit urgency, my lord, because this.
Please indicate the urgency. Hand over the slip. Yes.
Lordship, this matter was taken up yesterday as item number 9, Lordship, wherein Miss Monica Roy appeared for National Highway Authority. There is a new direction. There is a new notification dated 29th October 2025. Wherein
that is item number 9.
Yes, Lord.
What do you want now?
There is a new notification wherein the DM is supposed to do the removal of encroachment, lordship. So, as per your lordship's direction, National Highway is supposed to do the removal of encroachment, but as per the notification, it is supposed to be done by the DM, lordship.
Who was for the other side?
I don't.
To be mentioned. Please give a slip to be mentioned. Yes, call the list. Please hand over a slip.
No, I am for the petitioner, my lord. I don't want to proceed with the writ petitions.
I am for DSD led by Mr. Behan.
The learned advocate appearing for the যেটা taken on record লিখে দিয়েছেন তো?
Item number 3. Lord, in this matter, my lord, the parties were sent for mediation. Now we did not receive anything from the mediation.
Mediation failed.
No, no, no. On 17th of November at 3:30 p.m. in the afternoon, we received an email from the mediation center saying that please come at 4:30 on the same day. So we said, please give us some time to come. Then please give us any other date, we shall come. Thereafter, nothing from there. So on the same day, they give 1 hour's notice to come for mediation. But the interim order is dated 1st of August, where it was last ended till the end of November.
Well, we'll approach the mediation again, my lord, but I'm leading Mr. Gupta, my lord. We'll give them a notice, my lord. In the meantime, your lordship kindly
approach the
explain what
mediator. All right. So a date has been fixed.
No, date has not yet been fixed. My lord, this is the communication we received.
Yes, Swiss for the other side.
But we have given notice.
Union of India, nobody is representing.
Yes, but
Mr. Kaushik Dev, I suppose, appearing.
and
Led by
Tobik
Tobik
Nandi.
No one is appearing.
Mr. Nandi.
This matter, Mr. Gupta, Mr. Rai, learned senior advocate, appearing to virtual mode, prays for extension of the interim order. Full stop. He submits that the notice that a notice has been duly served upon the learned advocate representing the Union of India. Full stop. Paragraph. The interim order is extended till the end of the month of March 2026 or until further orders, whichever is earlier. Just call the next matter.
Grateful, my lord.
These applications are for extension. What is CAN 1 and CAN 2?
CAN 1 file করেছিল for vacating. That has been treated as opposition.
There were application filed for vacating, which was treated as opposition
Opposition to the main
to the main writ
petition.
petition. Are complete. CAN 2 was one
For
of our,
extension, my lord.
which was long back decided and disposed of. The order was extended.
CAN 2.
Yes.
CAN 2 disposed of.
It's an
একবার দেখে
extension.
নেবেন তো।
It's an extension application. It was disposed of.
CAN 2 তে একটা এ করে দিন, এটা দেখে নেবেন একবার। It has been ম্যাটার ক্যান ওয়ানটা থাকবে না না শুধু ক্যান টুটা যাবে ক্যান ওয়ানটা থাকবে
Can one?
ওটা থাক হবে আসলে মার্চ পর্যন্ত থাকবে ইয়েস নেক্সট
নাকি representation consider নাকি
I'm for the petition. I mean,
Yes.
Milord, the land acquisition proceeding under Act 1, Milord, Act 1. Milord, the award was published declaring that 62,231 per katha, Milord, while publishing award. One of the land loser, Milord, who is an award holder, preferred Section 18 application.
28A.
28A. Ultimately, Milord, it was enhanced from 62,000 to 1,32,000 something per katha. So I applied, Milord, my application is, Milord, within time as Milord 28A, Milord, page 13 of my Lord's brief. Indicating, Milord, the details of the enhancement in the Section 18 proceeding. Within 3 months, Milord, from the date of obtaining of the certified copy, Milord, I applied this. Page 16 is my
What has
prayer.
happened?
And Milord, thereafter reminder at page 17. Thereafter, nothing has happened, Milord.
Yes, what is your instruction?
Similar kind of
the
matter,
state-
Milord, page 21. Coordinate bench of your Lordship's court, Milord, have Milord directed, Milord, in a similar issue with regard to this. Same,
Milord,
in respect of same notification.
Milord, I'm yet to receive any instruction, Milord. So I'm praying for 1 week time for receiving instruction.
How long these applications are to be kept pending?
Yes, Milord, this pending for long, but Milord, I received the brief on yesterday only.
When this application was filed?
This was filed in April 2025.
And Mr. Mukherjee, where is the judgment enhancing the, you have not annexed that?
Enhancement and judgment. Okay. Milord, yes, I have, Milord, kindly takes up this.
So 1,32,000 per kata and 80,000, no.
That is not 80 lakh, is total,
Is
Milord.
the total amount?
Yes.
It's Shali.
Shali.
Your property is also Shali
Yes. I have not mentioned.
of the same acquisition
Same
proceeding.
acquisition notification.
Ashun. Evidence service filed in court.
I am for the respondent, Lordship. In this matter, the representation seems 28A, Lordship. Oh, sorry, Lordship.
Yes.
I am for the respondent, Lordship. In this
What is
matter,
your instruction?
similar case, Lordship, but here, Lordship,
Similar case is the petitioner's case is same.
yes.
Your case is also
No,
same. You have
Lordship,
not received any instruction.
I am, that is why, Lordship, kindly turn to page 22.
Yes. Page 22, yes.
Yes, that the representation, land acquisition, RS plot number such and such.
Yes.
LA collector case number such and such. In the last but one paragraph, I
Yes.
request your good self to make the estimate of in consonance with the judgment and degree passed in LA case number 186, LA case number 187, LA case number 188, LA case number 189.
Yes.
Lordship, which one he's involved?
All three out of one LA case various reference cases were made by some of the awardees. So this resulted in registration of 4 LA cases. 4 LA reference
Yes,
cases.
LA reference case.
All those were heard analogously and disposed of pertains to one acquisition proceeding.
Yes. For separately, that is why I am mentioning, Lordship, that must be dealt with separately, Lordship, not single.
Same analogous. Those matters were heard analogously. It arose from one LA case.
LA 4 of 80.
The parent proceeding is one LA case.
LA 4 of 24.
Out of that, several awardees preferred separate references, out of which separate reference cases were registered only.
And so one thing, Lordship, another thing is, Lordship, whether against the award passed by the LA collector for enhancement of the compensation, whether any appeal have been preferred by the state or not, Lordship. I got not instruction, Lordship. That is the reason, Lordship.
That they will decide, Lord, at the time of.
To decide what is your instruction on this? What is the stage of
Lordship,
28?
just for the
If
past
you have
time,
received that, you
for the
must
past
be
time,
knowing.
Lordship, last night, Lordship, I got
So
the.
this is the first instructions which ought to have been given by the authority. If a representation is pending, what is the stage of that representation? Without giving that, you are saying, I do not know.
Yes, at the time of hearing, all such things will be open to the respondent authority.
And I am asking you one thing. I have mentioned in the earlier order in accordance with law. Your learned friend was opposing to that. He was saying that I have to mention that an opportunity of hearing is to be given. That is to be mentioned, or your officers will act in accordance with the law.
Yes.
That is what I am asking you.
Certainly, in according with the law, and
That means opportunity will be given.
opportunity may be given, or section 28 opportunity should be given, Lordship. I'm saying this thing. Section 28 is a new amended section, Lordship, under the Land Acquisition Act. It was not previously. Now it is amended 15 years back, probably, Lordships.
এই দেখে একটু ল্যান্ড অ্যাকুইজিশন অ্যাক্ট একটু দিন তো।
More than that, 2000 probably. Previously, without section 18 difference case, there is no scope for enhancement of the compensation. But after 28A, Lordships, the similar situated landowners who have not applied for section 18, and they will get the benefit. That is why section 28 will come into force. Or 87 and 1980. কোন year এ হয়েছে ওটা মেন এটা?
We see 28A2.
28.
So this provides many things.
Yes.
So that is why I have said in accordance with law.
That is correct, Lordship. I'm in it.
ঠিক আছে?
Yes.
Everything same.
Same.
Date fit.
Only
same
the
order.
party's name will be.
Same order. Next disposed of. Yes.
We just lost it. Yes, sure. Item number 6.
Chief Lordship, I appear for
This
petition.
is
I
the
was
matter.
similar matter, my lord.
We are appearing for the state, my lord.
Application has been filed on 28 April 2025, page
Yes.
13.
What application?
My lord, application was 28A.
It will also 28A.
28A.
Same.
Same.
Date same.
Same.
Same order. Yes, next.
Deeply obliged.
7 also same.
Same.
7 is same. Yes, please give your appearance for the state. Yes, next. Every service filing code to is taken on record. Yes, next.
এই দুটো নিয়ে নিই।
I'm for the
I'm appearing for the state, my lord.
regarding unauthorized construction, lordship. Private restaurant construction unauthorized construction over the PWD land. In front
PWD
of the
land.
PWD road, lordship.
My lord,
Lordship in front of the.
You are for?
for state, my lord.
Yes, what is your instruction?
My lord, the representation, instruction has not come, my lord. My lord, representation should be considered as because, my lord, demarcation of the land is declared by the BLRO.
Lordship, page
That's
70.
why, my lord, let it be considered by the,
How much time this demarcation will be made by the BLRO?
my lord, 8 weeks. 8 weeks.
8 weeks. Why? Why 8 weeks? And thereafter, if any encroachment is found upon demarcation, how much time?
Then, my lord, kindly add on this matter for taking instruction, my lord, so that I can.
This application under Article 226
Well, this is my application. Lord, just my club went for service of affidavit of service, Lord, everything is served. All the Lord, they are the government respondents, Lord.
What do you want?
Here, Lord, here,
What do you want?
Lord, here, Lord, I am praying for Lord, consideration of my representation under Section 8 of the West Bengal State Highways Act.
Section 8 of
the West Bengal
show me
State
your
Highway Act.
representation.
Yes. Your Lordships, kindly, I will look up the page 48.
Page 48.
Yes.
Yes.
First representation, page 48.
Cannot be allowed.
Not only so the
Has to be rejected straight away.
state, not only
Straight away. From here.
it is not the authority.
That's why I am submitting. It is not the authority. This is not the facts.
Already after the honorable order of
Your
this.
pleadings. Please
Yes,
show
yes,
me your pleadings.
yes,
You are running a business.
Kindly hear me.
You are running a business for the last 20 years.
The temporary structure.
Yes.
In a temporary structure.
Yes.
Lord, what has happened?
What is the purpose?
The proceedings have been done under Section 10 by the authorities. Lord, enter.
Then it dawned in your mind.
No.
File an application under Section 8.
Kindly hear me for 2 minutes.
Appeal also. Appellate authority has part the order.
Lordship state way will not reject my application and Lord, the Section 10 proceedings has been done. Lord,
Against you.
Against all the persons,
Including you.
Yes, obvious.
Order passed under 10-1.
10-1, 10-2,
10-3.
10-3, last below 10-4.
10-4 also passed.
Yes.
Thereafter, Lord, after passing the 10-4 by the learned district magistrate, Lord, the writ petitioners challenged the said order before the
For implementation of that order.
No.
Oh, you have challenged.
I have challenged that order. Initially, this Honorable Court has stayed the proceedings. Proceeding means, Lord, the order. Stayed the order. Lord, during the pendency of that, Lord, I have applied, Lord, under Section 8 before the district magistrate because, Lord, the 10-1 authority, 10-2 authority, 10-3 authority has already passed the order. And also the 10-4. So, Lord, the questions of
authority below that rank.
Yes, that's why because I have applied before the 10-4 authority. And I have shown that the 10-4 authority cannot consider. But because of that reason, because 3 authorities have passed the order, including the authority under 10-4. So, my Lord, I have straightway, my Lord, applied before the 10-4 authority to consider my representation, my Lord, and to dispose of the matter, my Lord, in accordance with law. This is my, Lord, humble submission. Nothing more, nothing less.
Please show me the power of the authority. Under
Yes,
Section
my Lord,
8.
your Lordship, I have a look of the 10-4.
Yes.
Section 8.
Not 10-4.
Section 8.
Lord, may I read, my Lord?
Yes.
Permission to make encroachment.
Yes.
No person shall make any encroachment without obtaining previous permission in writing of the highways authority or any officer not below the rank of an assistant engineer authorized by him, not below the rank of assistant engineer, by him in this behalf. The highway authority or such officer may, having due regard to the safety and convenience of traffic and subject to such conditions and on payment of such fee or other charge as may be prescribed, grant a permit to any person to use or occupy temporarily any land appertaining to or adjoining a highway for such period as may be specified therein. Any person holding a permit granted so and so, therefore, my Lord, this is with regard to after, my Lord, holding the permit, the terms and conditions mentioned. Lord, let kindly, my Lord, see my representation. Kindly see my representation. At page, my Lord, I have shown just
before
1048.
going to a representation. All right, please show me.
Lord,
your
I'll see
representation
this.
first.
The paragraph 1 relates to that as temporary structure.
Yes.
Paragraph 2, my Lord, relates to my, my Lord, this business. Paragraph 3, my Lord, relates, my Lord, the
So you are running the business since last 20 years.
temporary structure.
Yes. Temporary structure for 20 years.
Yes. Because, my Lord, the road, my Lord, which has been
And
substantially
what is
extended.
the purpose for which you want permission? Please show me. You have to indicate the purpose.
Yes. My Lord, this structure of the undersigned is not causing any disturbance of the ingress and egress of anybody who are residing and are carrying on their business behind the back of their structure.
Yes.
My Lord, this structure which is situated 10 feet from the extended road of Contai-Belda State Highway.
Yes.
Thereafter, paragraph 5, my Lord, that the Contai-Belda State Highway Act has been substantially extended as proposed by the PW Department of the Government of West Bengal, and as such at present there is no proposal for further extension of the same. That since the undersigned is running his said business for a substantial period to maintain his livelihood of his family, it is essential to grant him permit to use, occupy, or occupy temporarily of the said land appertaining to or adjoining to the said highway for such period as may be fixed by you, considering the safety and convenience of traffic and subject to such condition, and on payment of such fee or other charge as may be prescribed, that the undersigned shall be obliged to produce the permit to be granted to him for inspection before the highway authority or any officer authorized under the law, and shall on the expiry of the period restore the said land under his use and occupation to its original condition, and make over possession thereof to the highway authority or the authorized officer thereof, that the highway authority may cancel and any permit to be granted to the undersigned if the undersigned violates any of the conditions either mentioned in the said permission letter or under section 9 of the said act of 1964, that the undersigned undertakes to comply with all the terms and conditions to be mentioned in the permission letter, and also to observe the provisions of the said act 1964 strictly. So, my lord, I undertakes, that means petitioner my lord, undertakes to comply all the my lord, terms and conditions to be provided, not if the my lord, sanction grants.
For what is the period for which you want this permission?
My lord, as the authority not thinks
You have
fit.
to pray for a period.
No, I
When the authorities.
my lord, I can pray for Lord, for my business purpose to remain the structure, temporary structure, my lord, as the authority thinks fit. If the authority thinks fit that this is for 5 years, Lord, I have to take this. I cannot not take my choice.
And at what stage this application under section 8 has to be filed?
Before the order passed by this honorable court in my lord, or challenging the order under 10(4).
I am asking you, what does the statute require? At what stage this application is to be filed?
Before construction.
Lord, before, yes, absolutely.
Demolish the construction,
My
pray
learned
under section 8.
friend is absolutely correct.
And my lord,
Demolish that, apply under section 8.
and my lord,
Give you liberty to file an
kindly see that my lord, order of this honorable court on 19th September.
Yes. I have seen that. I have annexed that also. I have not suppressed
Already
anything.
demolition
I have
order
not
has been
suppressed anything.
affirmed. Demolition
Then
order has
entire
been
things I should not say there.
Section
Only
8
one subsection.
says no construction, no encroachment without previous permission.
Yes.
Admittedly, this is without permission. Remove that. I give you liberty under section 8.
Lord, if your lordship
That's
knows
the
my lord
law.
structure is a poor
You have
man, my
applied-
lord structure.
That is why I said
Yes.
this representation need not be considered. It can be. That is why after seeing that, because I have considered this section.
Yes. Your lordship has seen that 10 and 8, your lordship is regularly considering under.
No. I have delivered a judgment, particularly on section 8. What is the effect of section 8?
Right.
When previous
Right.
permission, I have considered everything in that. That is why, after looking to that, you thought that I do not want
No.
to.
No.
Observation.
I know that.
Because I have seen
Lord,
the
I know that my. I
first
know.
2 paragraphs.
Yes.
One is
There
permission you have constructed. Second is it's for the purpose of running business. You have run for 20 years. You want to run it as long as you want. This purpose is for a temporary purpose, not a permanent. So the purpose for which you are seeking to encroach is a permanent. On this 2 grounds.
Not permanent. Now, my lord, what I am seeking.
Now I appreciate that you want for a temporary purpose. Please demolish that. I give you liberty.
Yes.
Under section 8, they will consider. I will also direct them to take a consider decision on that. But first you have to remove this.
Question is, for the blood equity purpose, blood, your lordships kindly consider this aspect. If I have to demolish blood, I will not be in a position to reconstruct. Yes, that's right.
Or section 8, you cannot let 10(4). I'm not saying anything when that will be
No,
executed.
blood, I am not on now 10(4).
The authorities whether to execute that order, implement that order or not.
I am not on 10(4) as I have been instructed that blood challenging the order of 10(4). Lord, the writ petition was filed, which was dismissed, and challenging that order of the honorable single judge, Lord, the appeal was carried on. That is different aspect. I am not on that.
I am not saying anything.
Yes.
10(4) may be set aside. Authorities, even if it stands, may decide not to implement that. That's
different aspect. I am also not. This is not also the subject matter of this application.
Section 8, firstly at this stage.
Section 8 only one Lord impediment for us. Lord, that section 8 provides that there should not be any structure. There should not be any structure, temporary or permanent, whatever you like.
And it's for temporary, meaning thereby structure has to be temporary.
Right.
Cannot be
No,
permanent.
it is bamboo structure.
You are saying that I am running for temporary.
No.
Section 8 for temporary purpose.
Yes. It is bamboo structure, nothing else. There is no concrete structure.
Sir, even for
For
that,
the
you have
bamboo.
to obtain prior permission.
Yes,
It says
yes, that I,
previous
structure
permission
for
in writing.
that I have to,
Have
that I have to bow
Mr.
down to
Mahato,
your
where is
lordship.
my earlier decision?
That I have to bow down by your
Also,
lordship.
have you brought my earlier order? You have not brought.
My lord, I have not brought, my lord,
Who appeared in that? Mr. Supratim Dhar was the petitioner.
my lord, my lord, if your lordship kindly come, my understand is saying that it is bamboo structure, page 61.
Question is structure or not? Question is structure or not?
There,
My lord is saying that there should not be any structure. My lord is saying that there should not be any structure.
Can apply only when there is no structure.
Yes.
Without, with the permission, after
Without
taking
going to say
permission.
that. This is without going.
After
I am
taking
only beseeching your
permission.
lordship, my lord. If I demolish my structure, my lord, in that event, my lord, tomorrow, my lord, I will not be in a position to my lord, stand here.
It is neither here nor there. If you want to take advantage of a provision, you have to come strictly within that provision.
Yes.
Because there is a purpose behind that. Otherwise, there is no provision also for post facto.
Yes, there is no provision. I have checked it up.
Then
I have checked it up.
I have
checked
dealt
it
with
up.
all those.
Yes. Your lordship has not passed the judgment on this point. Your lordship is just saying. So, my lord, only my lord, equity purpose, my lord, your lordships kindly extend your lordship's my lord, power under Article 226. Nothing else.
Cannot go.
And this cannot be create any precedent.
No.
This cannot create any precedent.
Yes. It will be because it cannot be. There may be many other structures. So allowing you and
Yeah, others will come. And my lord, in this event, my lord, the highway will never be cleared.
That means discrimination. Everyone has made structure for the purpose of their livelihood.
Yes.
If I recognize your right to livelihood, others' right to livelihood has to be recognized, and this is to balance the right to livelihood, not only yours, the general public. Why this encroachment is being prohibited? For the purpose of safety. Please see. Yes, safety and convenience. So by looking at your right to life, the right to life of others will be hampered.
Here, my lord, I am done is one thing. Here, in the instant case, my lord, I am lord I have made already this temporary structure, my lord, beyond 10-20 feet from the main road. And behind me there is no.
Make a representative.
Behind me, there is no person whose ingress and egress is disturbing.
It will not affect the safety and convenience.
No.
Apply before them. But first demolish this. Demolish, apply under Section 8. I will direct them to consider within a time limit.
Lord, if your lordship, Lord, that's the I am joining issue, my lord. Your lordship, if your lordship is saying that whatever your lordship is saying strictly in accordance with Section 8.
Yes.
Well,
because you have applied under Section 8. I cannot also go beyond that.
Without under Section 8, my lord, the authority has no power at all.
Show me any other provision which.
No, my lord, there is no other provision. I have checked it up. I have checked up the entire provisions of this particular act. I have checked it up. No, the questions is only
bound by my own decision.
That's right. That I can't, my lord, overreach by that. That's something.
Mahato, what is your instruction? What's happened to this application?
My lord,
you are sitting tight.
My lord, this.
Them you could have.
My lord, this representation, my lord, this is, my lord, there is, my lord, it is meaningless.
You from writing one line, this is not maintainable. This permission cannot be granted at this stage.
Already, my lord, this order of this novel code demolition has been, my lord, affirmed. Appeal up to appeal authority.
They should have said then let this application be considered. If the demolition has been caused, then
where is that? Where or Section 10(4) order passed? Where
my lord, if your lordship can come, my lord, page that is page
21.
No. What Section 28, page 28, my lord, the order of this honorable court that he has challenged.
Repression dismissed. Before that, my lord, there was an order of stay. And we
yes, challenge this 10(4) order in this.
Yes,
10-3 and 10-4 both. 10-3 and 10-4 both.
That was dismissed.
That has been
initially an interim order was staying that two orders.
No. The 19th of September it has been dismissed.
Right. And before that, my application has been filed.
Section 8.
Section 8.
15th. 19th order.
Client has come.
Anticipated this.
Client has come. I have advised him.
Yes, because when the client has come,
I have advised
You knew the fate of the writ petition.
No,
So you asked them,
I
this is
knew
only the way out under section 8 to apply. That was done.
That was done.
I knew the writ petition.
That's
That's
the date of filing of the writ petition, earlier writ petition.
earlier writ petition.
Yes.
The earlier writ petition was filed. I'm just giving to you. 2025, my lord. I'm just stated here.
So more or less at the same time, it came to you while drafting. You said
Initially,
section 8.
July,
please.
in the month of July or August, my lord, the writ petition was filed. Initially, the order was passed. My lord, kindly consider this equity portion, my lord. Otherwise, my lord,
But
if I went to
say you will demolish, undertake, then I give you liberty to section 8.
Lord, since they have not considered till yet, either reject or my lord, allow. Lord, they should.
Consideration is not mechanical. Direction for to consider is
No.
not mechanical. If you have a right to be considered, then yes. Prima facie, there is no right of your claim to be considered. I will go by that. I will say, I will consider that consideration, your prayer, I will record.
Lord, if your
Mechanical,
lordship-
any representation pending, directing consideration, no.
No, considering the present situation and facts
You
of
have to
this
show
case.
some right as highlighted in the representation. If you have some of the rights to be considered, yes.
But some of the rights, my lord, if I put in this fashion, that some of the rights means of not I have, my lord, made temporary structure for sometimes I am, my lord, I have, my lord, running my business to save our livelihood. That's why, my lord, I applied. This is my right.
And
So far,
what fallen
I
from
have
my
gone.
lordship that in 2014 Supreme
আপনাকে
Court
কিছু
it
বলতে
has
হবে
been
না,
said
জজ সাহেব,
that
জজ সাহেব বলে
representation is
দিয়েছে।
not automatic.
জজ সাহেব
If there is
বলে
some
দিয়েছে
right,
সব, আপনাকে আর বলতে হবে না। জজ সাহেব আমাকেই ক্রস করে যাচ্ছে আর আপনি ক্রস করছেন কি করবে? আমি দুজনে ক্রস করলে কি করে বলতে দেবো?
On which plot you have made this
Lord,
concession?
318. No, Lord, 38 is one plot. I am Lord 318.
Yes, you have constructed on 318.
Yes, just Lord, 20 feet from the Lord the main road.
Private respondents are there.
No private respondent. No private respondent. I'm against the government. I have applied before the government authorities.
All right. Affidavit service.
At my level best, your lordship. Not what can be done. I'm grateful to you.
ফোনটা দিয়ে দিন।
Item number 10. My lord, I'm for the petitioner. Affidavit of service, my lord, petitioner is a mining lessee, my lord. He participated in a auction process and became successful bidder. Thereafter, LOI was issued. The lease deed was registered, my lord. Due to public interest, the lease deed was shifted to some other place, my lord. Wherein
The area was shifted.
the area was shifted, my lord. The plot was also shifted. Thereafter, my lord, in the shifted plot, the mining plan was approved, my lord. Short-term mining license was also granted. The petitioner applied for environment clearance. Upon seeking cluster certificate and extended LOI before the competent authority on 16th March 2023, and the hearing was held up on April 12, 2023, my lord. The state level expert appraisal committee passed an observation wherein the petitioner's environment clearance application was rejected, page 76, my lord.
Environment clearance was rejected.
Yes, my lord.
By which authority?
By state level environment assessment committee, my lord, ACAC, in its 74th meeting, page 76, my lord. ACAC observation and recommendation, that part, my lord.
You are challenging that.
Yes, my lord.
Can it be a group 1 matter?
Group 1 matter, my lord.
How? It's relating to clearance of environment.
No. We are not challenging that, my lord. We are challenging
You said that order is under challenge.
No, my lord, no. We are challenging.
Which order you are challenging?
Yes, my lord. We are challenging the inaction on the part of the respondent authorities.
Show me which order you are challenging.
My lord, not any order, my lord. We prayed for LOI and extended LOI and cluster certificate, which was not granted to me by the competent authority.
Who will grant that?
My lord, the district magistrate.
Yes, Mr. Banerjee.
And thereafter, my lord.
Yes.
After my lord, at present,
I find that lease was executed in 2017. They continued for 2 years. Then there was shifting of the sand block. That is the position. I don't know.
Admittedly, the shifting of the sand block was approved by you. The mining plan was also approved by you. Now, what is the difficulty? Why are you not issuing that?
The reasons given at page 76 is that it does not fall within potential mining zone. I want to take instruction on that because if they have shifted, it has to be within the potential zone. Kindly come to page 76.
As per
Observation does not fall within the potential mining zone recorded in the approved district survey report.
ACAC observation, ACAC observation.
ACAC observation. This is regarding this particular lease. So now I have to take
What is
instruction.
ACAC?
State
Environmental Assessment
Appraisal.
Committee, Appraisal Committee. my lord.
Comprises this committee.
It's a Wings of Pollution Control Board.
That is why, what is the composition of this committee? If it is within the pollution control board, how can it be group
Kindly
one
come to page
matter?
74 Miller. 74 is the Miller constitution. It's in the conference room of Poribesh Bhavan.
No, this is in the
Page
conference room of
Poribesh.
Poribesh Bhavan. But these are all the members, but
They are the members.
My lord, our prayer, my lord, is that we did not get any cluster certificate and the extended LOI. That is our.
sir, cluster certificate has not been granted because of this observation.
No.
This ob-
My lord, prior to that, we prayed for cluster certificate, my lord.
Now this observation, if this observation is not removed, they cannot issue this cluster certificate.
But my lord, the plot was shifted by the authority, my lord.
That is there, but does not fall within the potential mining zone recorded in the approved such and such. Yes, Mr. Banerjee.
So kindly allow me to take back, come back with instruction because whether this is not within the domain
What
of
is the period of lease?
It was not 5 years.
5 years.
Expired.
Expired.
2 years. No, 17 years expired, but 17 to 19 he has executed, excavated. After that, Lord, from 19 onwards, shifting was instructed. So I'll have to take the instruction regarding the period also. Period for which they have actually excavated. So from 17 to how much? Period has expired. That is a fact. But it was shifted. He says that the shifted area, now we are saying that
Then a fresh lease is to be again executed
For the residual.
residual.
for the residual period.
So I have to kindly allow me to file a report, Miller.
Then, my lord, then, my lord, and a notification was at present. A notification has been published, my lord. Then a stay has.
Whether the decision is at the instance of the pollution authority.
At page 85, my lord, kindly see. The Department of Industry, Commerce and Enterprise published a notification, my lord. The below portion, all LOIs were revalidated by the district administration as per the above notification of the Department of Industry, Commerce and Enterprise shall be valid up to 31st December 2025 or 60 days from the date of obtaining environment clearance, my lord. Thereafter, my lord, at page 87, the district
Or 60 days.
or 60
Whichever
days,
is earlier.
whichever is earlier,
Yes.
obtaining environment clearance.
Yes.
Then page 87, my lord, kindly see. The district authority published the, my lord, see, kindly see regarding revalidation of the letter of intent and published a list of 50 highest bidder names, my lord, excluding my name, my lord.
Yes. So now how it can be extended now in this way? By way of an interim order giving you final relief, what will be decided in the final writ petition? What will be decided in the final writ petition? If this prayer is allowed now? Ashwin.
will
2 weeks
also
বলে দিল তো।
kindly fix
2 weeks বললো তো।
After 2 weeks.
published.
Yes,
Under same heading, well,
yes, motion. Yes, next.
Item 11. For the petitioner. In this matter, my lord, there was a direction to file report in the form of affidavit. I have got the instruction.
Yes,
I have got the instruction, but the officer could not come, my lord. He says that the affair after, my lord, on 9th or 11th, my lord.
what the instruction?
I have
What is
got
the instruction?
My lord, instruction, this is it.
What is this matter?
This is the removal of the unauthorized occupants from the government PWD road.
Demarcation done.
Demarcation done, patta has been granted.
Yes, now my lord, I am on instruction. I am someone kindly comes to my lord's order. Dated my lord 11th November 2025.
Yes.
My lord, the second page, third paragraph. The work of demarcation by the block land was shall be conducted upon prior service of notice to the petitioner and any other interested person who may be interested affected by such demarcation. My lord, on instruction, I am submitting my client. My lord, no notice has been served upon my client.
Mr. Mahato,
My lord,
notice was served.
Now, my
Is
lord,
demarcation done after this order or prior to this order?
After this order.
Was notice served upon the
No,
petitioner's
no,
issue?
no, my lord, notice, my lord, it appears there is no notice.
Mr. Mahato, you know
I know, my lord, but my lord,
demarcation, how it is done.
your demarcation is to be done, my
Without
lord,
notice, if
without
it is
notice,
done,
without all.
again it is to be directed, the same exercise is to be made. Why the authorities are not taking
My
care
lord,
of
they are taking the plea of SIR.
Mr. Mahato, that cannot be done.
My
That
lord,
cannot
that
be a
cannot be
ground
the-
to violate the order of the court.
My lord, that is my
So
practical.
another exercise, merely by saying that they are alleging violation, because the court order specifically directed.
Specifically directed.
So then this has to go, this demarcation has to go only on that ground. Again a demarcation, see the expenses and other things that are involved.
My lord.
You know that, what are the expenses and what is the time which is taken for this demarcation, and only for on this ground it is being set aside.
Well, this demarcation, my lord, without notice, my lord. I have told, my lord, told the officer that not only so he has signed the only the memo number forwarding, but not the order itself.
Who has signed?
The BLRO. He has forwarded the memo that has been signed.
Yes.
And it is, my lord, without date. Because Sarkar. I told him, the official who came, that this
So
should not.
now you have said that the petitioners have constructed within that area.
My lord, the sketch map is there, my lord. If your lordship.
Yes, so now it goes against him. So without notice.
Without notice, my lord.
Look at the problem now.
Without notice, my lord, this cannot be sustained. This inquiry cannot be sustained. Without notice, opportunity of all the parties should be given. Now, no one given. RI goes and demarcated it.
So I'm recording your submission, I'm directing you, I'm giving you further time, because
my lord,
I'm not accepting.
My lord.
Ashun. difficulty or you may be facing difficulty. Yes, I'm coming after 5.
Next matter is
Next is the same.
Next is also same. Next
Same.
similar mistake you have done.
Same.
Order date is same.
Same.
আচ্ছা next or same order করে Yes, Tolan.
I am for the petitioner, my lord, in this petition. The matter relates to payment of compensation.
For
And
the
it's actually not
state
long,
for
long past. But this is the second round of the litigation, my lord. Firstly, order is
Yes, report. Where is the report, please? What is your stand? What is your stand?
my lord, my learned senior advocate Shobhusaji Mukherjee is ill.
Their stand is, my lord, that the long pending and it has already been ended, so we cannot claim compensation at the present date. And and the writ petition should not be entertained as it is a long delay is there.
Yes. What do you say?
Kindly see their report, my lord. I am relying upon your previous order, after the honorable court, my lord, page 16, relevant portion, my lord. In the report, my lord, page 16.
No, have you disclosed the previous writ petition order passed in this writ petition?
Yes, my lord, I have annexed.
Where is that?
Well, on that basis, my lord, order has been passed by the my lord, authority, my lord. The page, my lord, page 53, my lord. My lord, thereafter, my lord, they took the hearing and they passed an order, my lord, which is, my lord, relevant portion, my lord, page 57, their order. Lord, they cannot, my lord, go back from the own order.
Where is your senior?
My lord, my
Where is Mr. Supratim Dhar?
Supratim Dhar, learned senior, is not.
Where is Mr. Supratim Dhar?
Sir, he is not happy.
Mr. Supratim Dhar has come.
No, my lord.
Yes, where is Mr. Supratim Dhar?
He has gone to the tribunal.
When he will come?
2 p.m. Huh?
Ask him to join
Lordship,
online.
kindly take it after 2 days, Lordship. Tomorrow also he will be not available.
Ask him to join. That cannot be a ground. That cannot be a ground. Appearance before the tribunal cannot be a ground for adjournment in the High Court. Ask him to join, if not physically, through online.
My lord,
2 p.m.
I will request him to join my lord.
2 p.m.
Virtually. 2 p.m.
Yes,
2 p.m.
ask him to join virtually at 2 p.m.
Virtually at
এটা রিপোর্টটা ফেরত দিয়ে দিন, ওনাকে দিয়ে দিন। At 2 p.m. Yes.
Same matter, my lord.
Same advocate. Here also Mr. Dhar is appearing.
No, I am.
Oh, you are appearing. Yes.
My lord, my Wasim, my lord, is the senior.
Yes. No, same stand.
Okay. Same stand. My lord, same stand, my lord.
Yes.
Claim, my lord. Stale claim.
Still
48.
claim.
Stale claim. My
All right. Return the land. Return the land. You need not pay anything. Please return the land. Where is the authority? You are possessing illegally. There is no acquisition. It's only 3-1, not followed by acquisition. And you are saying the acquisition proceedings was
I'm ready
completed.
to pay a market value. Market value, my lord, I ready.
You are saying that the acquisition proceedings has lapsed, it has completed, it will not be covered under 24A. Please argue. That's the stand in your report. Please argue. Please return the land. It's very easy to take land, not pay compensation, and then say, yes, for my inaction, you are not entitled. It's your inaction.
After 48
Maybe.
years, my lord.
What were you doing?
That's correct.
What were you doing? Why you did not acquire that?
That's true.
So, under requisition, can it be utilized for a permanent purpose? Please compensate damages per day from that day, because till that there is no acquisition. Please pay damages per day from that day.
Acquisition in 1970, 77, 78.
Show me acquisition completed. Show me.
There is 6 and 4. That's why.
Requisition, not
notice.
followed by acquisition. Act 2 lapsed, not converted to acquisition under Land Acquisition Act. That stood repealed. Now 2013, and you are taking the plea that that is not covered under 24. How could you retain possession of this land by requisitioning, which is purely for a temporary purpose? You cannot keep it under requisition for a permanent purpose. That's well settled.
Then my lord.
So you are entitled, you have to compensate per day. Then at your whims, please initiate a proceeding.
My lord, I take instructions, my lord. Then my lord, 2 days time, my lord. I ask my official, my lord.
They
My lord,
know everything.
My lord,
They could file this report.
Yes.
They could file this report. They know everything. They know everything. Let them pay these damages per day from that date. Then I will leave it open to you whether to acquire, not to acquire, keep it at that, when to acquire, under what
under
act to
PWD
acquire.
cost, my lord, road is there.
Yes, that is why you pay damages, requisition. So they are entitled to damages. You have not paid anything. Per day damages, please pay from that date till date.
Then my
to
lord,
acquire.
better, my lord, 2013, my lord.
That's up to you. According to you, it's a stale claim. Tomorrow.
Give 2 days time. 2 days.
What you will do with 2 days?
I will instructions, my lord. Details
This is your
instructions.
report.
Details
Are you
instructions.
withdrawing your report?
Verbal instructions, my lord.
Can it? This is on affidavit.
Yes, my lord.
And can the verbal instructions improve upon this? I'm asking you. This is your written stand. Even if you come up with some verbal instructions.
No, my lord. Then, my lord.
Then
my
that is
lord,
why I'm asking you. Are you trying to withdraw this report? Taking a stand on oath, verbal instructions you cannot improve.
Regarding my lord, whether keep payment within such and such, that's you lordship directed the matter, give payment within. Then, my lord, I asked you.
Payment under what act? How you will calculate payment?
So, my lord,
under which policy?
So that, my lord, I take instructions, my lord.
That instructions you have not stated here. So now you have not
Regarding my
volunteered
lord,
anything.
compensation.
I will decide what is the fate of that and what's the loss is. Because you have not taken any stand. You have chosen not to take any stand under any policy that you will be paying. Ashwin, the report in
Item 15.
Yes, what is this matter?
This is report was sought for from by the Honorable Court regarding the validation of the acquisition of a particular plot of land.
Corresponding CS plot number.
Yes.
130. You have mentioned in the report. What is the corresponding CS plot? Please show it to me.
May I have a copy of this report?
Yes, yes. Please give a copy to your learned friend.
Okay.
Which paragraph you have stated? On pencil or paper? CS plot number 130. So CS plot number is also 130.
130.
Mr. Raj, then what remains?
It is violated by my is RS plot number 130. I have arranged the deed.
So he has said CS is also 130.
Yes. So therefore, whether RS 130 is my lord, it is the query of the my lord. Will also can takes up the report which is the filed.
Today, which they have filed.
No, previously, my lord, can you turn to page 17? And before that takes up my supplementary affidavit.
Please give me a minute. So the notification was with regard to CS plot number 130.
Yes.
Mr. Rai?
Yes.
Notification, please give me. Notification was with regard to CS plot number 130.
It is there.
Now you, according to you, you have obtained an information under the Right to Information Act.
Page 5. My lord, supplementary affidavit. Page supplementary affidavit I have annexed.
Have you served a copy of the
Yes,
supplementary?
it is there. It is there.
Yes, page 5.
Internal page 5. The deed by which I am claiming title.
Yes. So you are the subsequent purchaser.
Subsequent innocent of which dog.
Yes.
Page 5, second one. Jela Dokhin Chowshwar, my lord, got it.
Yes, yes.
বগুড়া থানা সাব রেজিস্ট্রি সোনারপুরের এলাকাতে আমাদের কালেকশন রেভিনিউ
130 নম্বর দাগের
রেভিনিউ সার্ভে নাম্বার 174 my lord, got it.
রিভিশনাল সেটেলমেন্ট জরিপের এত নম্বর খতিয়ানে
খতিয়ানে যার হাল রিভিশনাল সেটেলমেন্টের জরিপের 652 খতিয়ানে লিখিত
So this is RS plot number 130.
130. I am whether this 130 subject matter acquisition or not. This is why prayer was made before the authority.
My lord, kindly come to the.
Show me, please give me a word. Show me the information supplied
Yes.
under the Right to Information Act.
That you lost on page 70, subject to question, my lord.
17.
17.
Yes.
If both the plots are said, there is no occasion on the part of the respondent of the issue by saying that RS plot number 130 is not the subject matter acquisition, but CS 130 is.
This right to information, Mr. Rai, I've seen in some matters. They are issuing information without consulting the records.
Keep me aside, my lord. I'm not on that also. Whether RS plot number 130 belongs to the government or not.
Because show me the notification. It says CS plot number. I think it's partly acquired. Where is that
Your
notification?
lordship will find this is the copy which have been handed out by my learned senior friend. That your lordship will find the notification.
That is in the report.
Yes, yes.
Yes, report.
Schedule of land.
Schedule of land, my lord will find that is annexure page.
Annexure 1, part of Annexure 1.
Part of
Yes, 130.
130 is clearly written.
Yes,
Loss Corporate Jurisdiction number 57, Police Station Sonarpur, CS plot number 20, 21, 69, 80, 130.
130. So it's in total,
In total, my lord.
not in part.
130.
Mr. Rai, from where did you get that it was acquired in part?
No. According to here, my lord, your lordship, the information which are they supplied.
Information is
That is
neither here nor there.
So I am keeping aside, my lord, this is now before your lordship.
So now 130, so the entire plot, CS plot number 130
130.
was subject matter of acquisition. And they say CS plot number 130 and RS plot number 130 is the same.
Absolutely, my lord.
So if that is so, if this was the subject matter of acquisition, you could not have acquired any title with respect to that.
If that is the subject of acquisition, it is acquired in the subsequent transfer, I am not entitled. My
Your claim was only on the basis of that information.
information.
That I've told, I think, in another matter.
So therefore, my lord, if your lordship may kindly, so this is a
Then what remains, Mr. Rai? Nothing
No,
remains.
no. So far, I have to consider whether this
My lord, kindly come to the annexer 3.
RS plot number, CS plot 130 is similar to RS plot number.
That is the report now.
That is why I have to go. I have to take instruction on the basis of the same. If it appears, my lord, both the plots are the same plot, then my lord.
Yes. What is the submission? Yes.
My lord, kindly come to the page annexer 3 of the report. Annexer 3 of the report.
Annexure 3.
Huh.
What is the annexure 1?
2, 3.
Annexure 2. Yes, annexure 3, yes.
For you not permitted to read. With
Yes, yes.
reference to the memo quoted above, the undersigned inform that the CS plot number 130, 130, 31 and 134 of Moja Loskopur, PS Sonarpur, along with others notified under section 401 LA Act 1 of 1894 acquisition. Draft declaration under section 6 for all the plots was sent to the government for publication in the Calcutta Gazette.
Yes, yes.
Already
there
is
is no
done.
dispute with regard to that.
After that, my lord,
After that, what happened? In
the meantime,
yes,
the amicable position of the land has been taken also by our department. On consultation agreed date has also been made. This office wide memo number dated such as may be treated as cancelled as the plot number were not connected mentioned therein.
After 1947, these plots were allocated to the RR department for rehabilitation settlement.
no, Mr. Office memo, LA memo number 65 was cancelled. This was replaced by this memo, 3074.
Yes.
So the earlier memo was cancelled because there was no plot numbers. Now this memo refers to the plot numbers.
Yes. CS plot number 130.
Now, Mr. Rai, your claim is that you have purchased RS plot number
130.
Now, there is no dispute. This renumbering in the record of rights in the subsequent settlement, the fresh numbers are allotted to the Bata plots which are being carved out. So, since you have purchased 130, it prima facie appears that 130 was the same plot as CS 130.
If you're also next,
unless you produce anything, because
yes, that is why my lord, page 18, next page, my lord, next
18.
page 18.
Yes.
Yes, sir. After report is, sir.
His report or your petition?
No, from the report. Now, my lord, my petition goes. I have to rely upon the report.
18.
Next page, my lord, annexure 4, last
page 17 I have. There is one page 18. I have only page 17.
Amicable position certificate.
No. Previous 18.
Previous.
Actually,
previous to 17, there is 18.
Oh, all right. Yes.
I tender my apology, mail.
All right.
Yes. I have this first day of 19th received the amicable position of the following CS plots in jail number such and such, Sonarpur, counter jail number Taliganj, unless the land is
130 is there. Position has been taken.
And can you consider 130 CS plot number, the plots, that is why previously my lord, can you consider Moja, Lashkarpur. My lord got it?
Tripur, Bagrachola, Bagargol. Already acquired.
Bagargola.
Yes. Plot number 130.
130 is there. Next schedule. Lower part. Second half.
CS plot number 30, 21, 20, 89, 130.
Yes, 130 is there. Amicable possession certificate.
Yes. Now man can consider jail number such and such. PS Sonapur is area of which more or less 34.1. CS plot number such and such. Where your lordship finds 130.
Possession taken.
It is an amicable possession taken according to the provisional certificate. Whether my lord, this provisional certificate, because it is cancelling the earlier gazette notification. Now this is a positional certificate. According to them, it is a positional certificate. By a mutual agreement, they have taken the position. So it is the duty of the state now to satisfy your lordship whether there is valid acquisition.
You have not made out that case, Mr. If you want to make out that
no.
case,
So primary matter, whether the CS is equivalent to this RS, whether the CS is RS are the same plot.
Same plot they are saying with time.
They are saying, my lord, if your lordship takes up day after tomorrow, either
that I can take up
because I have to consult only that thing. Otherwise, nothing. So, but this application is concerned, my lord, only limits to that.
And you have purchased when?
1986.
86.
Long after that.
Yes.
So according to
Tender was the awardee.
No. That is why, my lord, the award cannot be done. It is a mutual purchase. If it is a mutual purchase, then the acquisition, that is why, my lord, in the bottom line of this third
I am
paragraph,
putting a question myself, my lord.
No.
If I am, my name is not.
Mr. Rai, there is.
This office memo elevated such may be treated as cancelled as the plot numbers was mentioned therein. My lord, which is this memo? My lord, can you turn?
I am not the vendor. Whether I got awarded or not.
One thing, Mr. Rai, your plain and simple case was that this RS plot number 130
is different.
So now it appears declaration.
That is what precisely, my lord.
Are there. So if you want, because if that is your case, amicable possession, not possession in terms of this statute, no declaration.
Then I have to make a stress. I have not on that also.
Fresh writ petition.
The scope of the writ application is this, that I have purchased RS plot number 160, and according to the documents, it appears RS plot number 160 not been subject matter of acquisition. They came up with the information, no subject. RS plot number 160 not been acquired, but CS plot number 160.
Why your officers are giving this type of information?
If both the plots are the same, there is no occasion on the part of this saying that
officers in every matter this problem is being created.
Confusing.
You are mechanically issuing, no, this is not subject matter of any acquisition and other things. They are relying on this. They are filing the writ petitions. Look at the litigation cost they have incurred. Now you are producing documents. No, this was acquired pursuant to this. You are producing those notifications and other things.
And to that extent, my lord.
So these documents were available. So which documents were considered while issuing this, furnishing this?
Confusing report.
Mr. Dev, what is happening? How are you issuing these informations?
I have no idea. How information
Mr. Dev, I tell you, in every alternate matters, this is coming. They are approaching, obtaining the information. No, it has not been acquired. Files writ petition relying on that. And I think yesterday, so the information was supplied. 2 years after that, some documents have come.
Simple thing.
Mr. If it is a procured, if it comes to your knowledge, now you now it has come to your knowledge.
What steps have been taken?
What steps should be taken is one thing. What steps are you taking or have you taken?
it has come to the light.
No, not today. Right from the day I'm sitting in this determination. In this case, in all matters, I'm saying alternate matters. I think yesterday also I told Mr. Mahato was there or Mr. De, either of them was there. Previous also another matter, same thing.
Papers is there.
The information and the documents are contradictory. And this, look at the fate, only relying on that, he has approached. He's filing, look at the number of appearances.
Now he is saying that he will certain the same plot or not.
It is that, Mr. Day, that's a different thing altogether. Now he's trying, because since today this report has come, he has to take instructions from his client, otherwise he cannot make comment anything. But
From
prima
that-
facie, he is also satisfied that 130 was acquired and these are the same. Because it must be some bata numbers, those are renumbered in the subsequent settlement. So he knows, he is prima facie satisfied, but he cannot make any submissions because he's a creature of instructions. That is why he has to take instructions.
If the
That is
information was that
it's not that he has some doubts. As a counsel, he knows. What
Land has been acquired, but whether 130 is
now it's
compared with RS or not.
amicable possession, other things.
That is
That's a
something
different. That is not the case made out here. That's a different thing. Whether he will succeed on any other case.
That is something else, my lord, after going through the report of the
Whether
instruction.
CS 130 is RS 130 or not.
Requesting all of you, please instruct your officers not to give these mechanical informations under the ITI Act.
As
This
if
is creating litigations.
this information itself was there in
Might be in
plots,
other
several
courts
plots.
as well.
This is true. Vinod.
Because this information creates an impression there are two plots.
Yes. And your property is not subject
to acquisition.
The pursuant to the if there is also division bench. That's why. Next.
Item 16.
Yes.
In the morning, I have received the report. Same order, my lord.
Same order.
More or less.
Same order.
Now, my lord, kindly takes up the report.
Again, reply to the RTI information.
RTI, everything.
RTI information, RSCS confusion. Again, Lord, same case. But I would be paying Lord for dismissal of the petition with cost. Let me
Very well.
finish.
Yes.
Yes. Now, my lord.
He claims to be the owner of RS plot number 3413.
He claims, but the deed is 3410. He has purchased one plot and claimed relief in respect to another plot. I'll show. Let him show. Kindly see paragraph 1, prayer and the deed. Deed page 19, 3410, and he's asking for 3413.
So this is a type copy. No, no Xerox copy or the type copy?
Just copy of the type.
I want copy of the original. Where is the original?
That I'll produce. My lord, what is the issue before your lordship?
What is the plot number, Mr. Rai?
Yes.
Plot number is 341, RS 3410. From his
143.
deed. No, not 13. Kindly come to page 19. Completely not misleading.
No, 341. Thereafter is dot dot.
No, kindly come to page 19, the recital part. It was from 3410. His predecessor purchased 3410, then sold some portion of
page 19.
Page 19, can you see? Pulin Bihari Noskar has sold which plot? Then should be RS 3410.
Yes, Mr. Rai.
And we have also checked
3410.
And RS LR in the query part, LR number is 3413. LR is 3413. We checked, Lord. 3413 is the 3410 in RS.
Oh, 3413
So
LR is 3410 RS.
So he has purchased one plot, asking for relief in respect of another plot.
No, show me what is the relief he is claiming in respect of which plot?
Kindly come to paragraph 1
of the writ petition.
Writ petition. He is asking for paragraph 2. Petitioner states that by virtue of registered deed dated so and so, situated within so and so, PS Mauja Kamrabad,
RS tag number 3413.
But I have shown the deed to your lordship.
My deed is bad.
No,
my deed is bad.
This is RS dag number, LR dag number is 3413.
LR dag number is 3413 as per the deed.
So,
RS is
which is RS?
3410.
So, RS
3410.
3410 is corresponding to LR 3413.
3413.
All right. So now,
come to the prayers. He's asking for declaration in respect of 3413. Prayer A.
Prayer A. So it should be RS 3413.
That was prayed for.
That is prayed for. RS 3413.
No, sorry.
And he has
it should be LR 3413. If it is RS, because Mr. Banerjee, if I have to go strictly with this,
most of then he has no case because his case is dependent on.
No, my lord, I am coming.
So LR 3413.
Yes.
All right. So now, what is the declaration? Is not sought for any, is not the subject matter of acquisition.
Then
now, which plots have been acquired according to you?
Kindly come to page 55. He's heavily relied on 55. He relied on this RTI reply, which says RS 3413 has been de-requisitioned. RS 3413 is not his plot. Then on the basis of this, how he can ask for a relief? He relied on this RTI, page 55.
Oh, he says RS is 3413, LR is 3416.
3416. LR is 3416. Then the RTI is not in connection with his plot.
Mr. Rai, please show me your title with regard to RS 3413.
RS 3413.
Yes.
Your lordship can takes up the
schedule is blank. RS 341 blank.
That is, they have typed it from that copy. Where is the original copy?
If your lordship can takes up page 43.
43. Yes. What is page
plot
40?
number LR 3413 land details.
RS plot number 341.
So where is the deed, Mr. Rai? You are annexed this.
No, this is quite part of the deed.
This is the part of the deed.
Where is the deed? I want to see the deed. Where is the deed? You have only annexed that last portion of that certified copy.
Query was obtained for 3413. Query.
Query is with regard to the valuation.
But plot number is mentioned. Kindly see the land details. Page 43.
Yes.
Land details, schedule number L1, plot number LR 3413.
LR is 3413.
3413, which is RS 3410.
But you are saying in the representation LR is 3816 or something, 3416. Plot numbers are not telling.
3413 RS corresponds to 3416.
But
it is not his plot.
3410 corresponds to 3413.
LR 3413. He has purchased that 3413. So he has no document that his plot has been de-requisitioned. He has no document to make this claim in respect of 3413.
And this is corresponding to, please show RS 3410 has been de-requisitioned.
3410.
And he has to change the prayer also, because prayer is in respect of RS 3413.
Or Mr. Rai, there is a serious dispute.
Clearing my title over the.
Yes, because the plot numbers are confusing. Or if you say that in the representation you have made a wrong numbers, I give you liberty to file a fresh representation. It can be.
But the basis of his case is the RTI reply, my lord. That liberty cannot be given, my lord, because RTI reply mentions.
Even without the RTI.
He has no title in respect of that plot. If he can show that he has title, then he can.
Maybe not in respect of the plot which he has shown. If there is a typographical mistake, Mr. Banerjee, Mr. Rai cannot prove his title. But maybe, but he is the owner of some plot.
Yes.
So if his claim is that that has been requisition, let him make out the case.
Let him make out a case. That has been de-requisition. Then he'll have to get another RTI.
No, without RTI I can, because now I get that copy. The report I have received. So I am
at fault. Today I have given. I should have given a day before.
So now it appears that there is a mistake in the plot. If you have,
take it out day after tomorrow, I'll come and submit it for lordship. Because these are the things you got to consider. The
all matters day after tomorrow, Mr.
Yes.
Rai, all matters.
My lord knows, my lord is the creature.
Sir, Rai, please take up the representation. Everything is confusing.
Yes, but corresponding to
everything is confusing. Please take your representation as rightly Mr. Banerjee has pointed out. It says RS dag number 3413 and LR dag number 3416. But it's not so. Somewhere you are saying LR dag number is 3413. Somewhere you are saying RS is 3413. Everything is confusing. Or I can give you liberty. You can file a representation. Correct.
If he corrects this, then he has no document to show that
is something else.
LR 3416 has been de-requisition. Then he will have to show.
Tomorrow.
Day after tomorrow.
Not that he has
knows the places.
What place?
From where these are coming, my lord knows.
Yes.
That is why one day, because if today I inform, they will come by tomorrow at least. So at least 24 hours.
The report, the report of the Special Land Acquisition.
আমি ডিপ টার্নে সবচেয়ে বেস্ট হচ্ছে ডিপ টার্নলে হয়ে যাবে।
Yes.
In this matter, I am appealing to the petitioner. Last occasion, your lordship has been directed on 19th/11 that matter to be affidavit to be filed. The last chance. But
yes.
Date, but no affidavit has been used.
Mr. Bimal Kumar Shah is appearing on.
The report.
For the report. One copy maybe, my lord.
Yes.
My lord, I am appearing on behalf of estate, my lord.
Yes, yes.
Copy though.
Yes, what is this matter?
My lord.
My lord, in this matter, the railway authority illegally has been taken over possessions, and after that, my lord, interim order was obtained from this honorable court. After that, it has been transferred to the tribunal. The tribunal has been dismissed for default. Now, no restorations, no appeal was preferred. Nothing was done. Interim order is vacated. Now, after that period, he has been taking over possessions. Ultimately, application was made by the petitioner. The application was kept pending.
Yes, what is your
Nothing
stand?
Just now it has been
My lord, the said land, the alleged land was allotted to the petitioner. It's true in the year of 1984.
Yes.
And the petitioner had deposited the lease rent for the year of 1984. Thereafter, their petition is not in the possession of the land, neither he has submitted the
Not in
land
possession of the
lease
land.
rent, neither he is in the possession. It is the questionable mark on petition, my lord. In spite of that, my lord, please come to the page number 15 of my report, my lord.
Page
15.
Yes. Yes.
My lord, I have written to a letter to the advocate of the petitioner, last fourth line of from the bottom of my lord.
Yes.
You are kindly requested to submit the document with respect to the matter before the undersigned and better appreciation of the matter and submission of report by 25th, my lord.
Yes.
I am asking to provide me the document that you are under the possession of the property. Otherwise, you have renewed the land which I have given
Yes.
on.
Have you complied with this?
My lord.
This letter,
Page 15.
letter dated 21st of November 2025.
Page 15.
Yes. It was written to the learned advocate on record.
Yes, my lord. I have already communicated to the sorter of the my lord ADM.
So have you submitted these documents? You have been asked to submit these documents.
Yes, entire papers has been my lord, submitted to the office on my lord 28th.
28th
Totally
of November.
wrong
28th
submission
of
before
November.
your lordship. Please come to the
28th of November by WhatsApp.
Please come to the
Also,
P1,
my lord, those documents.
Annexer P1 of my lord, of the writ application, page number 15.
Please wait. Where are the documents?
28 তারিখের লেটারটা কোথায়? I have already submitted my lord on 28th personally, my lord, to my clerk.
Show me the documents that you have submitted.
My lord, please come to the page number 15 of the writ application, my lord.
Yes.
Letter.
Only I have allotted to the land to the petitioner's father. Petitioner's father has submitted the lease rent for only for 1 year. Thereafter, no documents is
No,
lying
I
in
have
this
already
writ
submitted.
application, my
Kindly
lord.
adjourn this matter, my lord, by day after tomorrow. But I will submit before lordship, my lord. Because I will personally, my lord, on 28th November.
Where are
And
those documents?
and my lord,
Please show me the documents.
Documents, my lord, WhatsApp, my lord, WhatsApp টাই বা কোথায়?
WhatsApp.
My lord, I have already written with the notice along with the annexes.
Show me, have you submitted physically or through WhatsApp?
Oh, WhatsApp, my lord.
Why?
My lord,
Why
you
have not deposited?
my lord, I will, my lord, the data that is, my lord, the hard copy. Hard copy.
Through
I will
whose
submit
phone
your
number?
lordship, my lord, the hard copy.
WhatsApp
Because I will to the office of the ADM dealer. Because my lord, he has already given request.
WhatsApp. What are you saying?
No, my lord, they have been, my lord, preferred this WhatsApp number. That's why, my lord, I will communicate it. My lord, even, my lord, I have also, my lord,
What are the documents you have forwarded? Please show me from your WhatsApp. What are the nature of the documents you have forwarded? All right, tomorrow, please bring the copy. Tomorrow. Yes,
My lord, one line order may be decoded because we are filing the report.
The report of
তো সহজে নিয়ে জিতে চলে যাবে। My lord, allowed to make a small section, my lord.
yes, tomorrow, yes.
I beg to appear for the petitioner. Your lordship would kindly recall, my lord, this matter, my lord, under the Parash Samadhan, my lord.
Yes, what happened?
Now, my lord, I tell you, lord.
Any solution?
Tried my level best. My lord, what has kindly takes, my lord, let them not proceed with the construction, my lord, at page 5 of the
That
report.
I think that order has been passed.
Yes, that's an interim order. Let that be made final, my lord. And in case, my lord, they wish to proceed with this, my lord, let them take due process of law. Kindly takes page 5 of the internal page 5 of their report.
So what remains, I can dispose it off by saying that cannot take any steps without initiating any proceeding for requisition and acquisition. Initiate that proceedings, do that. Cannot utilize the property of a party, private party, in that way. In the name of development work of a village.
Well, the Panchayat already abstained themselves. Panchayat authority completely abstained themselves in compliance with your lordship's solemn order. Well, just for
Abstention is nothing, you cannot do that, you cannot utilize without initiating a proceedings. If you want to, you have to initiate a proceedings, nothing remains. Why it should be kept pending? I am recording that. If you are intend to do anything, initiate an appropriate proceedings.
Stop the war from
Yes,
the
yes.
very day one.
So you do not intend to proceed further. I am recording that, and
My lord, my lord.
and if you intend to do anything, you can take steps for
My
acquisition.
lord, after filing the petition and my lord, after my lord, very passing the order of your lordship, my lord, completely abstain from this.
Yes, yes. I am recording that you are not. You have not taken any
no
steps.
intention.
You will not take any further steps.
No, my lord. I have no
Yes,
intention.
Mr. Banerjee, what remains?
My lord will cause the impugned decision, my lord, because they have taken a resolution. Page 5 shows.
Page?
Internal page 5 of their report.
Internal page 5.
Paragraph 1, they have taken this resolution. This needs to be quashed, man.
Yes, what do you say with regard to resolution?
No, no, this requires to be quashed.
Yes, yes, I'm asking you.
Well, actually, the main happened is well, this the land was very long back. My lord, the public are my lord, has been using.
Let them utilize.
Only
Yes.
for that.
Let them utilize. Don't
No,
make
no.
any construction.
My lord.
The Don't construct the villages.
Yes, that is stopped.
Yes, next.
Great.
Item 19.
19. In that matter, I am for the petition.
I am for the respondent number.
In the earlier occasion, there
Private
is a
respondent.
direction to submit a report whether the
Any.
land of the petitioner
Any.
acquired
Any.
or not.
Report was directed to be filed. No.
Yes, report.
Yes, report.
Yes, I have.
My lord, although I was not present, he handed over in my absence. I am not disputing. Let him complete his argument, my lord. Report, your lordship, will come later on.
All right. Yes.
My lord, let me submit on behalf of the petition. Petitioner is a subsequent purchaser. His name was recorded in the record of rights, page 36. Total land of plot number 5344, measuring about 29 decimal, and 29 decimal were recorded in the name of the riot. And the last one, petitioner is the last one, Srijeev Kumar Kaur, 6 decimal.
You are Srijeev Kumar Kaur?
Yes.
All right.
My name is as regards the 6 decimals of the land. The acquisition proceeding came to know the acquisition proceeding initiated in the year 75-76, but no compensation amount was paid. Only the structure value has been paid. That appears from the page 38 and 39 in the name of the vendor. 80% for the structure value. I have stated in my petition also.
Yes.
I have stated as page 8, para 12 of my petition. I have stated so.
Yes.
Thereafter, in 2025, earlier the land measuring about the road measuring about 30 feet. Subsequently, in the year in 2005, on 2025, the concerned authority came and wanted to extend the road in place of 30 feet, 57 feet, and further land has been marked, which is at page, my lord, kindly come to page.
But I will only request
page
he must
42.
not travel beyond
Page
the pleading.
42. Page 42 of the hand sketch map by the surveyor. The land has been extended further 27 feet, total 57 feet. Then the petitioner made a representation.
Yes.
In that context, it is necessary to point out that for the same issue, for the same road, 2 acquisition proceeding was initiated in the year 1975-76. LA proceedings 252 and 253. Our case is 253 proceedings. In the 252 proceedings, the owner of the land moved a petition where my Lord Justice Subrag was directed to consider the same as page 43 of the writ petition.
Yes.
43 and 44. Thereafter, on the basis of that, land acquisition collector took the hearing and passed the order that in the said proceedings, the structure value has been paid, no compensation has been paid, and so that proceedings has been deemed to have been lapsed as per 24(2) of the Act up to page 49. Thereafter, challenging the said order of the land acquisition collector, petitioner further came, the same petitioner further came at page 50 of the writ petition, where it is clearly stated, my lord, no compensation has been paid. 51 of
So
the
direction was given to initiate a proceedings under 2013 Act and to pay compensation.
Yes, my claim also the same. I have also the same.
This is not in your case. This
No,
is
no,
in the
no,
case
not
of
another.
others.
LA proceeding in the same issue, same road.
All right.
LA proceedings from or 252. My case is LA proceedings 253. I am paying subsequent purchaser. I have claimed the compensation, and also the vendor of the petitioner was made a party. He is respondent number 12.
Yes.
Very.
All right.
Yes.
Anything more?
No.
Yes.
There is submission. He is supporting, possibly let him support.
He is the
I am
vendor.
supporting the petitioner.
Yes.
I know that.
Yes, yes.
I Should be rely. clear to reply. Yes. I rely upon the some decision, my lord. AIR 2016 Supreme Court 4275.
For what proposition?
Yes.
As regards the
The AIR 2016 Supreme Court. Delhi development. Yeah. Something.
4275.
4275.
For what proposition?
What is the position? After the land has been purchased, the name of the petitioner has been recorded. He become the recorded owner of this land and interested person in this matter. And he is also.
Which paragraph?
Paragraph 12. Paragraph 12, 13. 12, 13, 14.
No, the 12, 13, this deals with interpretation of section 24. You said that even after acquisition, if the name of a Rahat has been recorded, he becomes the owner. Show me that paragraph.
Oh, yes, yes.
Because 12, 13, 14, section 24 is being interpreted.
Yes, yes.
Please show me that paragraph where you said that even after acquisition, if a person's name has been recorded in the record of rights, he
Yes,
becomes
yes.
the owner.
Twenty-four. Land acquisition policy under the act and
কোনটা এটা কোন
getting to
condition
have
এর?
lapsed.
No, 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 no. He become. Concept will change. Concept, my lord. Concept of ownership will change. Ownership.
You have cited,
Yes,
sir,
yes,
that
sir.
proposition, you must
Yes,
be
yes, yes.
straight away going to that paragraph. Because when you read that proposition, it struck me that that is why I asked you which paragraph says so.
I was trying to record it so that I can be careful that record of right holder is becoming owner.
All right, come at 2 p.m. Have you seen the paragraph? Have you found out the paragraph? We're trying to find out. Come at 2 p.m.
2 p.m. My lord. Already 150. Next matter, my lord. State is at here. Report. My lord, for report, my lord.
Yes.
I have brought that. But since we got the report, it's a otherwise going like a bit in opposition. Let them, I believe.
My lord,
we are
3-1A. Up to 3-1A, thereafter nothing. That is why my lord called.
All right, I will see. I will be taking out after this.
My lord, in that event, my lord.
will not be available at
Second.
Why?
Let him come with the reply, so that I can fight it because specific government, the leadership which is relied upon, that is not in the. There is a paper one. I think.
পরেরটাতে একটা order
Number one.
For the opposite party, my lord.
Item number 19.
My lord, I face wrongly that judgment will be, but reference will be year 2017, 70 Supreme Court, paragraph 19.
Yeah.
Year 2017. 17, paragraph 19.
Page code.
Page 2450. 2450. 2450. Paragraph 19.
Paragraph 19.
19. Landowner. Paragraph 19. Landowner under the 2013 Act is defined under section 3 smaller, which reads as follows. Landowner includes any person whose name is recorded as owner of the land or building or part thereof in the records of the authority concerned, or any person who is granted that applicable in this case, and thus amongst others, a person whose name is recorded as owner of the land or building or part thereof in the record of the authority concerned is a landowner. And person
2013 Act the right to fair compensation.
Could I hand up?
Clear. Definition forward.
Yes. Yes.
Yes, and petitioners also claim the compensation as per the Act 13, 2013, Act 30, and rightly have described his declaration also claimed that also rightly I support him in this case because he has already claimed for compensation as for proportional compensation along with the landowner.
Yes, I am sorry. Anything more? No,
Well,
anything more?
no.
Yes, Mr. Advait.
But I start from the end. Kindly see the landowner defined, whose name is recorded as owner of the land or building or part thereof in the record of the authority concerned. Authority concerned defined in 3F.
3F.
Good.
Yes.
Authority means the land acquisition and rehabilitation and resettlement authority established on this. So not the LR authority. Anyway, my lord, I am not on that.
Now, 75, 76 requisition started in respect of part of the land, not the full. The land in 5354, 44 is 29 decimal. 12 decimal was sought to be acquired and notices were issued. It was not completed. That is
It was Act 2 of 48.
Act 2 of 48. Requisition.
3-1 order was passed.
4-1 also was done.
4-1 done.
But ultimately, award was not passed. Naturally, my lord, it lapsed. Now the question is,
but the property utilized.
Yes.
Property utilized.
Yes. No, that is his case.
Property not utilized.
Yes. My lord, when they were saying, I was.
Don't interrupt. Please take your seat. Do you have a chair behind you?
Sorry, my.
Please take your seat.
I was totally mum.
Please take your seat. Yes.
My lord, from the purchase deed, Lord will find at page 26.
26.
26. Schedule.
Yes. This is the petitioner's purchase deed.
Yes, purchase deed.
Yes.
He has purchased 6 decimal. 5354 out of 29 decimal.
Yes, 6 decimals.
Yes. Then, my lord, it is demarcated. সবুজ রঙে রঞ্জিত স্থানে উত্তর বাহু, kindly come to the next page. Uttar Bahu, your lordship has got it.
Yes, it's Uttar Bahu is 35.56. 35.56 on the northern. Yes.
Got it.
Yes.
Then, my lord, Dokhin, it is tallying.
Yes.
It is tallying. And road is also there. Sarkari Odigron, bottom.
Yes.
Paka Rasta, next bottom.
Yes.
Sarkari Odigron, then the next bottom is the Paka Rasta. So he has purchased a plot which was
partly acquired or partly requisition.
No, this portion was not acquired.
No, his portion was not acquired.
Other portions acquired.
Yes.
12 decimal out of 29. And he has admitted in his petition to that effect. Page 4, para 2.
Page
4, para 2.
Yes. Yes.
That on such and such date, by virtue of registered deed, he is purchasing in 2025 in 28th of April.
Yes.
Petitioner purchased a piece of land being plot number such and such, area 0.06 acres out of 29. So 29 is the total land. He has purchased 6 decimal with share such and such. And, my lord, beyond the acquisition portion of the Public Works Directorate, Midnapur Highway. He got his name recorded. His record of right is there, that he has shown at page 35. Lordship sees my lord Rajiv Kumar Kaur. Has your lordship seen?
Yes.
5354.
Yes.
Jol 0.06.
This is 29 decimals.
No, total is 29 decimals.
Yes. His is 6 decimals.
And 12 decimal has been acquired. Sought to be requisition and acquired.
But here that requisition portion has not been mentioned in the record of rights because it was not acquired.
It was not required. It was not required. So, my lord, kindly come to page 27, 26, 27. That I have thought
yes, it's 0.29 acres, not 29 acres. It's
yes,
29
29 decimal.
29 decimals. I was under the
I
impression
stand corrected.
you said 29 acres.
No,
That
no,
is why
0.29 acres.
29 decimals.
29. My lord, I stand corrected.
Yes.
My lord, I have shown his portion at 27, what he has purchased. It is tallying with his deed, and this is not coming under Sarkari Odhigrohan or Paka Rasta. And he has admitted in his petition. To that extent, I have shown. Now he was referring to page 42.
Yes.
Page 42 is a surveyor report, private surveyor's report.
Yes.
It's not by the government.
No. Yes.
This private surveyor's report. And that also does not reflect anything that it has been %80 was paid to the vendor. Vendor is fighting his right. He has shown the orders. I am not on that.
Yes.
So, admitted position is that out of 29 decimal, 12 decimal was sought to be requisitioned or acquired for the purpose of road. Admitted position is that he has purchased after 50 years from the date of requisition, 50 years, 6 decimals, and got his name recorded. Had it been a case that it was acquisition or like that, then it would not have been recorded.
But only one thing, Mr. De, please kindly come to the schedule of the deed.
Schedule of the deed, yes.
Yes. So schedule of the deed with regard to that extent.
Yes.
Uttor Bahu, Dokhin Bahu, where you are relying upon.
Yes.
Uttor Bahu, Dokhin Bahu. Now please kindly come to Purbo Bahu and Poschim Bahu.
Purbo and Poschim.
Both of 153 links.
Yes.
Now please now come to the surveyor, private surveyor's map.
Yes. Why I will rely on it?
No, that's different. You say that from that also it's not being shown. That is why I'm trying to show you.
He must be trying to show 106.
Yes, one thing, please see in the private survey, you may or may not rely upon, that's a different thing. In this private surveyor's report, you will be finding the sketch map. So now you will be finding this PWD, this hatch line.
Hatch line, yes.
Yes. So you will be telling that Uttor Bahu and Dokhin Bahu is 38.56 and 40.44. Measurements are given in the sketch map.
Correct.
Now on the Purbo and Poschim, you will be finding that's 153 links.
That he has
now here
he has broken A, B,
yes.
C, D.
So according to him,
no, this is not coming on the road. Purbo and Poschim is not coming on the road.
Mr. Dev, PWD according to him, this 41 is PWD utilization. That's his case. That's his case. He's trying to
establish.
Yes, establish his case, and in support of that, he has given a sketch map by a private surveyor. May not be binding upon you. That's a different thing altogether. But this sketch map says this 41, and this 40.44, this measurement, this according to him is the utilized portion from that property. That's his case.
41.
Yes, because this is the area. You have got this sketch map.
Yes, I am on it.
So if you get this 112 plus 41, if you add, this is 153. Yes.
He wants
on the right hand side also 112 plus 41 is 153. So that's the Purbo Bahu and the Poschim Bahu.
He is trying to establish.
Yes, that's his case. He's trying to establish that this square portion of his plot, he claims to be the owner of plot number D, which is marked as D in this sketch map. So he claims that this portion of 40 links, 41 links, 40.44 links, 41 links, and this 38.56 links. This is the area which has been acquired.
Not established anywhere in the.
Now the question is, so that is his case. Pure and simply, you may not have made that in these representations, Mr. Day. If you are strict on those pleadings and these case made out in the representations, most of the writ petitions will go. So now that's he wanted to establish. Now there are two things. What was the order under section 3.1? Because 3.1, what is your report? What is your case? Have you taken any portion of that plot or this portion?
Nothing is reflected. Nothing is reflected. That is why I had to go through all the petition,
No, because so I could get, subject to correction by them, from this case map, that this might be their case that a portion of that plot was acquired. The entire plot 3854, a portion was acquired. Now, a portion of that acquired falls part of his plot, which he has purchased.
That is he's trying to.
That is trying to establish.
Kindly come to my lord.
Now, admittedly, no acquisition.
Kindly come to page paragraph 6 of the report.
Of your report,
my lord. Only 2 pages, 3 pages.
Where is the report? Report file করেছেন কোথায়?
He has filed. He has taken copy from me and filed on the other day.
Earlier occasion, I have handed over a copy.
Brief note.
Yes.
All right. Yes.
Kindly come to para 6.
Yes.
On verification of official records by relay case number such and such, it transfers that 0.10 acres, that is 12 decimals, of the land in plot number Ato was requisition.
Yes.
It is telling as I have submitted 12 decimals.
Yes, was requisition. Then what happened?
Then it was not completed.
4.1A done.
4.1A done.
Possession handed over.
Possession handed over to that extent.
Yes, to 12. No dispute with regard to that. 12 possession handed over.
He comes within 12 is no, it is not his case.
Yes.
It is not his case.
That's the case.
No, paragraph 2. Beyond that you may be saying, beyond the acquisition. My lord, this is court of record. 226 is the court of record. Kindly see paragraph 2. Beyond the acquisition.
Now, Mr. Day, even accepting all this, he may not be entitled to. But the fact remains 5344, a portion has been utilized.
Yes. That order has been already made in favor of the erstwhile owner who has sold.
So, yes.
That orders are there.
So, whatever the arrangement between the erstwhile vendor, so when you have the erstwhile vendor he's transferred his entire property.
No.
Portion.
Only 6 decimal.
Yes. So
out of 29 decimal. And beyond requisition. Kindly sees, my lord, the orders that has been, my lord, passed in his case, the vendor's case.
Not vendor. Where is that?
That is vendor and not.
Vendor. Where is that?
That was the submission made. Pradeep Kumar Bhakto.
No, they are similar case.
No, that is a similar case, Mr.
Yes, same roads.
Not his vendor.
Vendor.
His vendor is Bhakto.
No, same.
His vendor is
submitted.
Let me see, my lord. I may be wrong. ভাই আমি ভুল বললে আপনি আমাকে সংশোধন করবেন, আমাকে দেখতে দিন।
অনন্ত কুমার ভক্ত।
অনন্ত কুমার ভক্ত।
Acquisition proceeding for the sale simple.
Yes, Anant
Kumar Bhakto.
Anant Kumar. My lord is right.
Yes.
So,
but this is Pradeep Kumar Bhakto. This is a different thing. Now, have you have utilized a portion, 12 decimals?
12 decimal, and admittedly not his portion, which he has purchased in 2025.
Not only. No compensation has been
This
paid.
is the difficult.
No compensation has been paid.
Sir, this is not your writ petition.
Yes.
By supporting, you cannot make out your own case.
Yeah.
No,
my
Lordship, kindly.
And you are bound.
His case is
Sir,
pending.
don't open your mouth too wide. You are bound by the recitals and the schedule which shows beyond the acquired portion. So admittedly, what you have transferred to him is beyond the acquired portion. You cannot travel beyond the deed also. He cannot also claim anything. So I can proceed basically on the basis of the deed, and I can please take your seat. Yes.
My lord, his case is pending, he is saying. So if his case is pending, that would be decided.
His case is pending.
My-
for
My lord,
purpose.
vendor's case
I
for
also-
compensation is pending.
Compensation, no, my another writ petition also pending.
That will be decided.
Decided.
That will be decided.
Yes.
But from this, you have transferred
Yes.
an area beyond the acquired portion. So he is not entitled. Ashok.
My lord, kindly come to paragraph 14, 1-4
Yes. Of
of the writ petition.
please, please take your deed. You cannot claim anything beyond your deed.
Yes, deed
Yes.
I have said, but
So please show
what-
me the schedule.
after the deed
Yes.
executed, thereafter the proceeding was taken. For that, this is paragraph 14,
Sir,
1-4.
what is the property? Please kindly come to your deed first. Then I will go to other
For
proceedings.
for initially the land road was 30 feet wide, and thereafter on April 2025, the concerned authority came and measured the plot and wanted to extend the road 57 feet. Therefore,
Sir,
therefore,
there are two LA cases of 252 and 253.
yes.
So with regard to 252 and 253, you are not concerned with 252 and 253.
No, I am a concerned.
252 and 253, you are not concerned. So, so according to you, a fresh proceedings in April 2025 was initiated.
For that
Sir,
reason,
what is your
Where is
instruction?
that? Where is
paragraph 14, my lord.
Paragraph
14.
14
Yes.
of the writ petition.
Yes. That after 4 decades or more, the highway authority, with support and assistance of the local police station and representatives of the local panchayat, came to the spot of the land again to take possession by
On the
demarcating.
basis of the earlier lapsed acquisition cases. Yes. You have said earlier lapsed acquisition cases, not a fresh acquisition case. That's not your case made out.
They wanted to. Why
You have not made out that case. You have said on the basis of the earlier lapsed acquisition case. It's not your case in paragraph 14 that a fresh proceeding was initiated. That's not your case, sir.
That the concerned authority wanted to
Maybe.
widening the
You have
road
not made
in
out.
place of 30 feet, 57 feet.
You have not
Extra
substantiated
20
anything. You have said pursuant to the earlier lapsed proceedings. Earlier lapsed proceedings.
Earlier.
And Mr. Dey, what's your stand with regard to paragraph 14?
Paragraph 14, my lord, he is annexing the notices. Notice is that page 39, that my lord, lapse proceeding. Page 39.
No, apart from that 252 and 253, no proceedings was initiated. Have you stated anything in your report?
No.
Have you stated anything in your report with regard to that? That these are the only two acquisitions?
Because his case is confined to LA case number 253. That is why the report has this.
He has not said where he has said with regard to 253.
He has annexed that. Yes, kindly come to. He is saying two cases, 52 and 253.
Please kindly come to his paragraph 14 once. Page 8.
Yes.
After 4 decades or more, the highway authorities with support and assistance and the representatives of the local police panchayat have come to the spot of the lands again to take possession of demarcating line and fixed a subsequent point of acquisition of land about 27 feet wide, more land than the previous mapping marks, and line which was average 30 feet wide on the basis of earlier lapsed however present marking. So he has sought to make out a case may not be in that very words that the initial was 30 feet, the earlier proceedings. Now, further widening of, sorry, initially was, yes, 30 feet. Further extension of 27 feet, that proceeding has started now. What's your instruction on
No
that?
proceeding has been started. He has not stated any proceeding has been started.
No, he has said that you are trying to
That
map this.
that
What
is
is
a
your
mere allegation. That is a mere allegation. That is a mere allegation. And on the contrary, he is referring to, my lord, the earlier notice of.
No, maybe. Can you file a report with regard to paragraph 14 only?
No, no,
That
no.
no steps
No,
have been
paragraph
taken.
14 is clear.
No,
He is
paragraph
making.
14, he says, Mr. Dev, may not be the language is not very clear. He says, by the virtue of the earlier proceedings, it was 30 feet. Now, 27 feet more is sought to be utilized, mapping and other things. This is being done recently. That is after 40 decades of the earlier proceedings. That's the case which he has
He is
sought.
trying to. This is mere allegation report.
So file a report that
There is
you have
no
not taken
whisper.
any steps with regard to that end of the matter.
But is it required after he says?
Sir, he is
No,
making a statement.
after he has admitted that he has not.
No, after that.
After
Oh no. After 40, you have purchased in April.
Yes.
When did they come? Where is the specific date?
it is made out.
Where have you made out a specific case?
Petition. Demand of justice.
What demand of
Representation.
justice? What have
Demand
you
of-
stated?
April 25 he purchases and September he gives a demand justice.
Yes. So when did they come? When did they come?
Nothing else is stated.
As per the measurement taken, my lord.
No, measurement, private measurement.
Private measurement, 42, page 42.
That is private
That
measurement.
is how much portion has been taken by the PWD?
The acquired portion, what has been taken, compensation, you have
No.
filed a writ petition. His portion is beyond the acquired portion. So if it is utilized, you will be having your rights. Ashun. The Yes.
First order item 13.
Yes, where is Mr. Dhar? All right, not today. When is the other matter coming? Tomorrow?
No, Thursday.
Thursday, এটা কো Thursday করে দিন। Thursday date লিখে দেবেন পড়ায়। Yes, next, call the next matter.
Thursday.
21.
13 আর 14 Thursday. 13 এবং 14 Thursday. 13 এবং 14. 13 এবং 14. ওটাও Thursday হবে।
We have now taken out a writ petition which is item number 22. This is not like restaurant matter where the allegation was that a hookah bar is being operated.
22.
22 is my writ
21 is
petition.
my writ petition.
Correct.
21 is your, 22 is his.
21
He's
by
the private
landed
respondent
enjoying.
in my writ. He's the
Yes,
private
so-
respondent in my writ. I'm the private respondent in
You are enjoying an interim order in your writ petition. Now let me hear Mr. Banerjee.
So grateful.
But only
Because-
one instruction before Mr. Banerjee starts. No, so I'll just take 30 seconds. I'll not interrupt him. He'll place his case.
30 seconds by the clock.
Only, my lord, one instruction that we have. We've gone through the writ petition. We've gone through his writ petition, my lord. There are certain factual allegations that he makes. We wanted to address it by way of an affidavit in opposition.
That has
If my lord so desires, he can place his case.
Yes. Din. 22.
Now the gamut of my writ 22.
22 you are appearing.
Yes, my lord. 22.
Yeah, Mr. Mojumdar is leading me. Kindly allow me to comments may ago. That before my lord looks to my writ petition, I just indicate what my petition is all about. I say that now because of the notification published by the Urban Development Department, citing clause 2 subclause 10 of my lease deed, that clause has yielded in this notification. So today, if there is any permission required in terms of clause 210, that is what is required under this memorandum only. Now, this memorandum, this notification rather, nowhere contemplates any objection, no objection to be taken from a so-called co-lessee. If the notification does not require that, subsequently by just putting forth a pro forma format in which I need to apply before them for the no objection for the permission, they cannot insert a clause which is not even contemplated in the notification in which clause 210 has yielded. So this footnote
challenging. What is your
I am challenging this incorporation of the footnote in the format in the application format, number 1. Number 2, I am challenging the inaction on the part of the authorities in withholding the so-called permission, because it has now been
applied for permission.
Long back they have submitted a report.
Where is that application?
It will come back to my, I'll just indicate it will come back to my lord's mind also. Mr. Bivek's surname Bosch. Mr. Bosch was appearing. He made a submission, submitted a report in my learned friend's writ petition saying that application was submitted, but they returned it because the application was not accompanied by a no objection.
Yes.
My learned senior has come.
Yes, Mr. Mujumdar.
Fight over property between two sisters, for which not the
Can you not settle it, Mr. Mujumdar?
it got settled.
Got settled?
Yes. Now not really extortion now.
It got unsettled.
Extortion, not there is no end to one's need. That there is a registered deed of assignment, which we wanted to carry forward in 2025 April. Thereafter, we applied for license. All we obtained the trade license, everything.
You are a third party.
No, I am a lessee. No, the applicant for the purpose of running a business is a lessee.
So
now it is it's a lessee within the meaning of the agreement.
Yes.
Lessee. Now the other sister suddenly got annoyed with the assignment, which was registered.
May not be the assignment, Mr. Mujumdar. I think their allegation was that some disturbances is being caused with regard to some smoke and other things. Can you not sort it out?
Only one thing.
That is the problem, Mr. Mujumdar.
Your Lordship has seen the 2015 notification of the government.
I've not seen anything because just Mr. Banerjee started.
My Lord, please come to page 44.
Yes,
I'm sorry, page
first
82.
let me
Page
see
82.
What reliefs you have claimed. set aside the show cause notice written the nature to accept the application of the petitioner seeking permission without insisting for consent of the private respondent to quash and set aside the show cause notice. Show cause notice, Mr. Mojumdar, you have to reply, let them decide on
No,
the
no,
show
it's
cause
fait
notice.
accompli now. It's fait accompli. The government has said
Show cause is to for the purpose of
permission.
closing down.
Permission.
So unless and until you submit your application,
I did.
No, it was returned. So
On the ground which is now before your lordship.
yes. So now, unless you submit your application and make a conscious decision on that, so thereafter you can run. That's the one. Now you are challenging, according to you, that contains a clause that you have to obtain the consent of the private respondent in your petition for applying for permission. According to you, that is not contemplated under the notification.
Or even under the law declared by the Honorable Supreme Court.
Please show me that.
Yes.
Please show me that. Where is the notification?
Please come to page 82. Only 2 pages, not page 82 and not page 31. Please take these 2 pages side by side.
82 and 31.
My lord.
Mr. Dev, you are having all the instructions.
No instruction. Today, my lord, I got this.
Because Mr. Mujumdar is fully ready with this matter. He will be arguing on points of law, I think.
I shall try to.
Yes. So that is why I'm page, other pages. 82 is one page, other pages.
32. 31 and 32.
That is why I'm asking you.
Today is my lord.
The government decided terms of lease got subsumed by a notification issued in the name of governor.
Yes, page 32 is the lease deed. It's the parent document.
Yes.
So parties are bound by this.
Which got modified.
Show me the clause. Which clause you are trying?
Please come to page 32 now.
Yes, 32.
Because clause 9 is no longer relevant.
Yes.
At page 31, the last clause at page 31 is no longer relevant.
Yes.
Please come to 32.
Yes.
But it's a restraint on the lessee not to use or allow to be used the land or the structures thereon or any part thereof for any purpose other than for residential purpose without the prior permission in writing of the government
yes,
or other authority prescribed in that behalf. So not the extreme restraint on the lessee.
No, it's only for residential.
Only for residential.
So you cannot use without the prior permission.
So tacitly it could be allowed provided the government would permit.
With permission you can.
Now, please see, for any purpose other than for residential purpose.
Yes, so it's only for residential. So you can change the mode of user with prior permission.
Now, normally this is statutorily done by municipal bodies. But there are several statutes under the Town and Country Planning Act, KMC Act, Municipal Corporation Act. These are normally done by parastatals of the state. But not for this Salt Lake area, Vidhannagar area. What the parastatal of the state was required to do has been taken over by the executive authority of the state. Now please come to page 82.
Yes.
April 2014 August 2014 it was in the active consideration of the government. Now please take note of each and every word or phrase used in this particular notification. Now it's gazetted. It was in the active consideration of the government for some time for inclusion of a few more permissible categories of business. Activities of non-residential nature in residential buildings in the context of notification number so and so dated 22nd August 2014. Now 22nd August 2014 is not available on the website. Not despite our best of research or search, we have not been able to lay our hands on this. Not the government can probably produce this. After careful consideration of the matter, the governor has now been pleased to decide. So this has to be in exercise of executive authority exercisable under Article 162 and 164 of the Constitution of India. After careful consideration of the matter, the governor has now been pleased to decide that in supersession of order earlier issued in this regard, the permission for non-residential use only up to 45% of the total floor area of residential buildings would be allowed.
Yes.
Subject to the following terms and conditions. That there are enlisted categories of business. So the inclination is what was an unfettered right in clause 10 of the lease deed is now being subsumed by the control of the executive authority of the state, so that there is no ipse dixit or irrationality permitting into an executive function. Now please see the first condition. The lessee will have to obtain prior permission from the urban department in terms of clause 210 of the lease deed. Now this 2.9 is not relevant for our purpose. 2.10.
210 is, yes.
Now this 2.10 read with the recital to this notification renders 2.10 to be subsumed.
Yes.
Because not the phrase used is would be allowed. Would is to be read as shall.
No suggestive permission, duty. Not a discretion.
Yes.
Then please see not the next clause. This is all the more important. The lessee will have to pay rupees 80 per square feet as permission fees in addition to application fees. But this is really conversion or permission fees, which is normally done by a planning authority or a parastatal of a
Are you
state.
challenging this also?
No, no,
or-
no. I'm
not challenging.
No, no, no. I'm
So don't, you can skip those because.
no.
there are
I'm
other-
only trying to demonstrate not from the purport of this notification that what the state government was doing. What was a negative or restrictive or injunctive clause in the lease deed is now shifted to an obligatory duty of the state in exercise of its executive function.
Is this restaurant within this list of permissions?
Yes.
That very.
Please come to the next page, 83.
Yes.
Serial number 7.
7 is doctor's
Yes.
consultation chamber.
And please see not 40.
Lawyer's chamber.
Lawyer's chamber. Not how can this be controlled by 210?
No, but Mr. Majumdar, let us not go into that.
No,
Where is
that's
that
not here.
restaurant
This notification on the same page, same intention. Today, not when I am not going into the.
Go into the lawyer's chamber. Maybe difficulty, some interpretation.
No, I am not.
So,
But I have
for that moment.
I brought this statute also for this purpose. It's West Bengal Clinical Establishments Act.
Yes.
Not a doctor's chamber.
That restaurant where it falls.
Okay, no, it comes. No, please come to serial number 45.
Mr. Majumdar, I have a division
Yes, yes.
bench at 3 p.m. How much time we will take?
Not almost finished. No, I come back next day. Please,
Order
I request Mr. Day to produce that 22nd August 24. No, we could not lay our hands on that.
Mr. They, please supply a copy of this notification of 22nd of August. We have referred to in this notification at page 82.
82.
Give a copy to Mr. Majumdar.
Look,
As
there-
well as to your.
I'll take it from you. No, there does not appear to be a lot of scope for an interim order. Could we come back with affidavits?
No, not
At the
today.
the shortest possible time.
Today, we have a judgment delivered by this honorable court. Insofar as running of hookah bar is concerned, if it is no nicotine, no tobacco, but I don't know what is all this about.
No, it's commercial. My allocation.
It's a flavored hookah bar.
Whether
And it's a restaurant. But I have got the licenses.
commercial enterprise, and that case in there, writ petition is there is a
Now you are enjoying an interim order. Now why you are trying to delay this process?
I'll take a week's time. They've also taken like a week's time.
They
to
should
come
deposit
back.
the salaries of the employees in the court then.
They are running an
They have
illegal
taken a
business.
week's
They're asking
time,
for
but they are
salaries.
suffering an
And
order.
they're making an allegation.
It's not that they have taken a week's time and they were enjoying
No,
that.
no, the interim order was passed post the affidavit stage.
And on his writ application.
Or even if it wasn't. Well,
Yes, Mr. They, when can you supply this?
Notification.
Okay, sir, Mr. Day.
that wasn't my
What are you saying?
Yes, my lord, you cannot fix the date. I must say that you must give me the.
Please tell me day after tomorrow. Because this is a copy because Mr. Mojumdar says that could
It's not available on the website.
on the website. Otherwise, he could have brought it.
West Bengal action
So
notification.
your officers may be having this.
Yes, should be having.
Because this has been referred to is this notification.
এই কোনটা চাচ্ছ তুমি
এই
Please come to page 82. Please kindly, Mr. Mojumdar, please mark.
ও এইটা
2014
এটা পাওয়া যাচ্ছে না ওয়েবসাইটে।
Mr. কটা দুটো ঠিক আছে
Item number 1.
But I am for the respondent in this matter, my lord.
yes it's a review
A review was preferred, my lord, by the applicant, by the applicant's minute, but thereafter, my lord, this matter was upheld by the division bench judgment was upheld by the Supreme Court. We have filed an execution. Long has happened since the filing of the review, and they have not even moved this application for once also. So, my lord, in all likelihood, it has no relevance as on this date because the review of the
we
Supreme
cannot
Court.
pass any orders on merits we can only dismiss it for the court.
Yes, my lord. Yes, my lord. I'll be obliged. My lord.
আসুন।
Item number 2. Or I am for
Well, it is violation of your lordship's order dated 22nd September 2025, my lord. It is
violation
and
contempt
yes, your lordship, my lord, page 22, annexer A2.
first time
No, second time.
there was a direction to serve
Your lordship, my contempt application, this order was passed by your lordship, my lord.
contempt application
Page 22.
দেখি contempt application কোনো
Contempt application was heard on 2nd September 2025, my lord. That is page 22. Page 22 of my contempt application, my lord. Answer A2.
it was disposed of why it should be revived what is the ground
The direction was given to file, my lord, fresh representation.
yes
Yes, fresh representation was filed.
so if the fresh representation was filed that gives rise to a new proceedings why this should be disposed this should be revived
My lord, your lordship at page 25. Page 25, my lord. Page 25. My relevant portion, my lord.
comply with
Page 25. My second last paragraph, my lord.
yes Mr. Ghosh what do you say
Well, the proceeding which was initiated, that has been ended, my lord.
so
And when I've got a report, my lord, to that effect, we have been taking steps regarding the demolition part, whatever we have
how
found.
much time it will take Mr. Ghosh that is why he has paid for revival of that and there was a specific observation in page 25 if you kindly
The
come
proceeding has been ended. Proceeding has been concluded.
thereafter if it is not within the time if the compliance is not made show me under within what time it was directed to be completed and whether you have completed or not if you have completed end of the matter if you have not completed then
Proceeding has been completed. Thereafter, courts are given certain directions regarding that. After if it is found, then certain actions to be taken regarding disconnection of water supply and something like that.
yes
And we have already directed the concerned department to get it disconnected because the departments are
when
different.
you file the representation
My lord, your lordship, my lord.
have you annexed that
Yes, yes.
which page
annex, my lord. In my contempt application, page 26, my lord.
26.
26 on 9th September 2025.
September, this order was passed.
Yes.
So time was extended till 3 weeks.
Yes, 3 weeks.
So from 2nd of September, 3 weeks time it has elapsed, Mr. Ghosh. Have you complied with?
But I find, my lord,
Till date.
in this case, the order, my lord, was passed under section 400 subsection 8, not, my lord, under section 401, but regarding that 408, my lord.
Mr. Ghosh, the jurisdiction is limited here.
My lord.
Please kindly come to the order dated at page 22, 2nd September.
22, my lord.
Page
Yes.
22, the order dated 2nd of September 2025. By this order, the contempt application was disposed of. With the observation, if you kindly come to page 25, the first paragraph. So the time to
Time stipulated in the order dated 27 November
extended by
20.
3 weeks from date. So it was extended to comply 3 weeks from 2nd of September. So it's 23rd of September. So have you complied or not complied with? If you have complied with, say that.
My lord, we, my lord, issued the order, if it is, my lord, correctly reading of the report, the 15th of September 2025, the demolition order was passed.
Then Mr. Ghosh, we are reviving the contempt application, you file a report. If you cannot show today that you have complied, or if you can say that yes, it has been complied with, then we have to revive the contempt application pursuant to the earlier order, and you can file your report to say that whether you have complied with or not. Record of this report. The report of the হয়ে গেল।
কবে উঠবে এটা?
Yes.
মানে let it appear.
The appellate side matters.
Let it appear on the note.
That we cannot say because only the revival that application was assigned to us. Yes. Yes, next.
Appellate side matter, item number 1. Matter, Lord, I'm the respondent. Lord, it was disposed of.
Why it is appearing?
A gentleman is not appearing in person. May have not persisted your lordship to address this matter. Your lordship will kindly have a look at the order dated 2nd of May.
2nd of May.
Lordship,
Where is that order of 2nd?
2nd May 2025. By this division. Like a hand up.
No. We have got. Pecho. No. Mr. Mukherjee, can you give me one copy of your?
This is right.
Application stands dismissed.
Yes, we are unable to understand why this matter is appearing to. We thought that not it might be such that the applicant might have mentioned before you know. The appeal was disposed of.
Appeal was disposed of.
In 2019, then he took out an application for addition of party. That is also disposed of.
Signing of the decree. No, Mr. Mukherjee, that please see this note. Decree assigned by signed signing of the decree.
Well, I understand.
ডিক্রিটা কোথায়? Passing it, or you can also please have a look at that. Decree আছে Barpur. Yes, I was also then I found that order 20 rule 8 that was
Yes,
quoted.
that has been quoted.
So
and we understand the purpose because Justice Tandon has been transferred and the degrees were made.
Yes.
But I'll just try to find out if
Yes.
it has been drawn up and back to the file.
Let's call the next matter.
In number 2,
Yes.
So this is our appeal. Our appeal.
Yes.
Respecting the appeal against the rule of contempt issued by the Honorable Single Judge. My Lord Mr. C. Bhattacharya was sitting with the Chief Justice. We obtained an order of stay for further proceeding. And Mr. Sen, appearing for the writ petitioner, submitted that he shall take the preliminary objection.
Where is Mr. Sen?
I don't know. That is recorded in the last order.
I'm leaving
That the
Mr.
preliminary
Saputin,
objection should be hard fast.
Yes, yes. Stay is continuing,
Yes.
but where is Mr. Shane? Maybe where is this junior?
Senior Advocate Shakusin is occupied in court number 36, Your Lordship.
Where is his juniors assisting him? He may be engaged. Where are his juniors? It's a difficulty for fixing another date.
We're seeking a short passover, Your Lordship.
Short passover, Miller, one number has been called out before court number 37.
After a while, he will arrive.
order sheet.
Then another date may be fixed. Because it will take some time because we have just strictly argued and also help from my Lord Mr. Bhattacharya. There is a doctrine of merger. There is any
It will be taken at the end of the list, Your Lordships.
That about we have so many things to argue.
Then has to be, cannot be in this year.
After finish. And we can peacefully argue.
January.
Lordship, he's on the way. Just got
Another matter has been called on.
Within few minutes, Your
Not
Lordship.
called on, likely to be called on.
Likely to be called
It's a
on.
very serious matter also.
Asun. Yes. Next.
Item number 3.
Application for review with additional documents.
Yes, my lord. Yeah.
Well, sorry, my lord, I was very late. In the last matter, I was there, but I was actually instructed to pray for time. The matter has suddenly appeared.
Suddenly, cannot aage danni list?
No, for me, it was a bit sudden. I'm not saying about the port.
We have posted it in the second week of January. Because
Obliged,
this year,
yes, we shall get ready in the meantime. Obliged, Lord.
No,
Yes.
sleep is in a
sleep in. Sleep in.
For the last order, there was a direction that additional documents which my learned friend has relied on before the Honorable Supreme. Well,
I think we directed to file a compilation. Yes.
what has been done is, the paper book which was filed for the Supreme Court has been crossed out.
Oh, that is also not served on me. He has given these two things to me. No, these two things to me. What no?
Let me clarify.
Relying on whether so that we can
What no?
file out.
Mr. Mukherjee, before the Honorable Supreme Court, you relied upon some additional documents which were not placed either before the single judge or before the division. So now you know what are the documents you relied upon before the Honorable Supreme Court. So can you not make a compilation of those documents instead of annexing the or giving a copy of that SLP? SLP may be containing very,
SLP we have not supplied, we have not served, my lord.
That is what I am showing.
your learned friend says you have supplied, Mr. Chatterjee says you have supplied 1 or 2 documents.
Kindly see what we have.
This is the letter, additional document, and this is the document.
If you say that yes, we will be relying upon only those
Very well.
documents,
I
then
don't
it's
have any
fine.
objection. I shall
Fine.
I shall make my submission on this document here and
If you
now.
want to rely upon some other documents, then you have to give copies to them, and you have also to make a compilation for the court also.
This copy was never served on us.
This is the copy we have served upon.
No. He cannot produce.
Everyone.
No. He cannot produce this.
So
This
Mukherjee,
copy
your
was,
learned senior friend is objecting to that.
This is the copy.
Look, you have served different copies to different your adversaries. You have served him a copy of the SLP. You have served Mr.
Here is the copy.
this is the SLP copy.
No, this is not the SLP. This is the additional
This is
document.
the same copy.
Yes, Lord.
Your Lord,
Chatterjee,
can you see
please-
SLP number such and such?
Mr. Chatterjee, please check up what is showing. Is it the same document?
SLP number such and such.
SLP
No, it's-
number has to be given, Lord.
Please see, check up whether this is the document which you has been served.
My lord, this is what has been served, but this is the document which has been produced before the Supreme Court. My lord, and my lord, kindly-
But directed
my lord, may I indicate, my lord? My lord, may I indicate, my lord? My lord, kindly.
All right, Mr. Chatterjee, you are having that copy.
No.
You are having. So you are not ready.
No, not at all, because I thought it as per my learned
What
friend.
now it has been served.
No. I thought it SLP. It was used before the Honorable Supreme Court. So I did not go through the same. That is the whole difficulty. If he could. No. If
Have
he
you filed that document?
Yes,
Court.
we have filed before the honorable.
My lord, my learned friend should indicate what are the documents, because
the bulk of documents, which document?
These documents we have relied on in the review application itself.
my lord, kindly
Which are
you are also taking
Lord, kindly finish up the review application for once, Lord.
yes.
Review application.
And we have filed a
Oh, acha,
application for
the review memorandum. This is the memorandum of review. Where is the application? Is Can 2.
Can 2, Lord.
All right.
No one has
Can
been
2 page,
disposed
sir.
of.
Can 2 is the order application for interim order.
Yes. So that's the application in support of the memorandum of review.
Yes.
Yes, Mr. Mukherjee.
Can you come to page 16, Lord?
16. Yes.
This is the first document we have relied upon.
Before the Honorable Supreme Court.
Honorable Supreme Court.
All right.
And these are the documents which are specifically relied upon, nothing else, Lord.
Very well. Your Lordship.
So, Mr. Mukherjee, the documents which are part of Can 2,
Yes, Lord.
we will be relying only on those documents.
Yes, Lord.
Mr. Chatterjee, are you ready with this? Because
No,
these are the documents.
Yes, the documents which are part of the
Can 2.
Can 2 in respect of the registration of the vehicles, because his main contention, so far I understand from your Lordship's order, that the registration of the vehicles has been done on December 8, and the time to upload the document was November 29. How he can upload? That was the issue raised before this Honorable Court, before the Honorable Single Judge, before the Division Bench, and before the Supreme Court. Most likely, he thought it Supreme Court will not pass any order, setting aside your Lordship's order. That's why he shortcut method. We also take the shortcut method. We will file review, give some additional document which we know.
Chatterjee, now
But
the
that
liberty has been granted by the Honorable Supreme Court.
now the additional 1 minute, my lord. Your Lordship can see what are the additional document, and from the and from the additional document, can it be proved that it has been uploaded?
Chatterjee, that's up to him.
Yes.
So he says he will be relying upon only on these.
This.
Whether he stand or fall, that will be only on these documents.
Very well.
So let him substantiate his case only on these.
Yes.
That your lordships will decide, my lord.
Yes.
Whether these are the genuine document or not.
No question of genuine. I thought it is genuine, which he has given.
Mr. Chatterjee, are you ready with this? Are you
As far as the documents are concerned, I am ready.
You are ready.
This is the part of the registration.
Yes, Mr. Mukherjee,
There
start.
is a direction
Yes.
for affidavit in opposition. These documents are not are illegible.
We have served another copy, my lord. We have served another
Sir, if some eligible documents were served upon you, what prevented you from writing to the learned advocate on record saying?
my lord in court.
It was directed in court to serve as a copy of the.
That was not done. What prevented your learned advocate on record to write to them
Irrelevant.
that look, these are the illegible copies which have not been. You take these grounds for adjournment, then these matters cannot be taken up.
May kindly grant me a week's time, then I will file my affidavit in opposition with it. Because from the compilation, we cannot see what are the documents which he is
In this
relying
compilation,
on the
it is very difficult to tick out.
Now he has come up with this.
Now come up with this very well, and in this document application also, there are certain illegible documents there.
So, this
Lord,
Mr.
we have
Mukherjee,
again
Mr.
served
Mukherjee
on-
only one. These documents were not part of the writ petition or the appeal.
No.
So they have to be given an opportunity to deal with this.
Opportunity was directed to be affidavit was directed to be
Have you filed the affidavit?
No, my lord.
Why?
Kindly see the order.
But
number
in
25.
my case, I missed the order. It's my mistake.
Lord,
It's my
25th
mistake. It's nobody's
25th of
mistake.
September, Lord, kindly sees.
Why have you not filed illegible copy?
What are the documents he must indicate? The documents are the
This
same.
can too, sir. These are the documents annexures from page 16 to page 42. Don't you have the copies of page 16 to page 42?
My lord, I have
These are the documents he will be relying upon. Do you wish to file any opposition to this? Asun,
page 16
Asun,
to 45 are illegible. My lord.
Lord, we have again filed and we have
Sir
again said.
Mukherjee, please give a legible copy.
But again we have given
Of
your lordship's order, Lord. Kindly see this letter, Lord.
legible copy.
Kindly see this.
Mr. Mukherjee, do you have a better copy?
Yes, Lord, we have.
Serve it here and now.
Legible copy কোথায় দিয়েছো বাবা?
Please serve it here and now. These issues should not come.
No, this
Should be resolved prior to the matter being listed.
Lord.
Mr. Mukherjee, please give up legible copies of this document. Ashun, the learned advocate. In 26.
My lord, in the meantime, copy may be served on us.
The learned advocate on record. Weeks. 2 weeks, 1 week, second week of January.
Item number 4.
Yes, only one thing. Password. Yes.
The degree has not been drawn up, only because the note has been put. The last 2 pages of the order sheet.
Note that degree
Yes,
was
that-
not drawn. Where is that?
No, it was sent to the degree section and thereafter, this note has been. দুটো একটা পাতা থেকে হ্যাঁ 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 ওই সাইডে
Was sent to the decree section on 3rd of September 2025.
And your lordships passed that order dismissing that application, and thereafter, now either your lordship may dispense with drawing up the degree, or the formal. But now your lordship has recorded that we have complied.
But maybe the decree has to be drawn up because
Leave it to your
also there is a observation. There's a administrative order directing that placing this for this quoting order 20 rule 8. Ashwin. This matter has been assigned to this bench in the light of the provisions contained under Order 20, Rule 8 of the Code of Civil Procedure.
Item number 4, learned Solicitor General is virtually appearing.
Yes, but I appear for the IRCTC.
May I please?
Yes.
My lord, as per the court order, my lord, we have filed the application for the condonation of delay, my lord. My lord, this is the review petition, my lord. Kindly appreciate the reason for which, my lord, this review petition has been filed. My lord, there is the judgment of this honorable court in DVC matter, my lord, Damodar Valley Corporation matter. In that particular matter, this honorable court has interpreted the integrity pact of the government document, my lord. As per the court order, the court held in that particular judgment by interpreting section 2G and section 3 of the integrity pact and holds that disclosure by the bidder is necessary even for the period of last 3 years. Means thereby, if an FIR has been registered and the matter is going before the trial court at the time of the submission of the bid, the disclosure is required. The party cannot take the shelter since this FIR has been lodged before a period of 3 years. Therefore,
I'm sorry, my learned friend is arguing on merits. There is a delay condonation application.
Where is the application? What is the period of delay?
My lord, 272 days, my lord. And the reason.
Do you want to file any opposition to this?
Well, we will have to, the reason being, my lords. I'll just point out, my lord, a few dates and we'll place that on record. My learned friend's argument is that one judgment of your lordships did not consider. Thereafter, that judgment of your lordships was relied upon by Delhi High Court. And Delhi High Court accepted that judgment, against which SLP is pending. And there is an interim order passed in the SLP. Now the problem is, Mr. Bilwadal Bhattacharya's client is already awarded the contract. He is operating. I am IRCTC, my lord. We are serving food. We are distributing food, my lord, in the on railways. So they have installed kitchens. They are already serving. So, my lord, that would go against my learned friend, my lord, coupled with the fact that non-citing of one judgment can never be a ground of review.
Yeah, that's on merit. That's on merit. But if you want to file any opposition to the
We would, my lord, because
My lord,
equities are
my lord,
created because of the delay.
Yes.
My lord, kindly understand my difficulty, my lord. The period.
No,
of
it's
the
a Section
contract is
5
for the-
application. I am for the private respondent. It's a Section 5 application. First, they have to overcome the hurdle.
Because the delay has to be
Yes,
taken
they have to
into
overcome. I say, my lord, this.
How can I shut them out?
My lord, what my humble submission is, my lord, on the last date of hearing, my lord, the direction has been given. We have served the copy in first week of November itself, my lord. The contract is for the period of 5 years.
Without a direction, how can we file an affidavit?
No direction was passed to file any opposition.
My lord, there were no, my lord, my humble submission is, my lord, this is only the technical application, my lord, only, my lord, more than
Technical.
1 year has been passed. And my lord, the
Technical or not technical.
No, it's
if
not
they have,
technical.
They have
My
a
lord,
right to
delay
file
is never
opposition.
a
How can I
technical
shut
ground.
them out?
My lord, the present difficulty with the petitioner is, my lord, 1 year of the contract has already been lapsed, my lord. Ultimately, the petition would become infructuous, my lord. And
Correct,
at
but
present,
not
there is
because of
two
our fault.
contradictory judgment of this honorable High Court, my lord, on the same point, my lord. There are two contradictory
That's on
judgments, my
merit,
lord.
sir. Unless the delay is condoned, cannot enter into the merits of this matter.
My lord.
So, Ashun.
Take 3 weeks.
3 weeks. The learned advocate.
My lord, once the
Hey, how can that be? What type of submission is this?
Kiola, please.
About 27 after the vacation.
You're saying 3 weeks. 3 weeks takes
27.
us to 23rd.
What? We are just on the 2nd of December. Very good. 3 weeks, yes.
This
23rd.
exactly 3 weeks.
We posted after the vacation, my lord. New year, new vigor.
The 3 honor.
We fixed, my lord.
Second week, sir, this is a broken bench. Both of us have respective single benches.
Hello, at least
So
they
date
may
will be
be
because
fixed
the
2 days
calendar
before, my lord.
calendar for January is not yet published. So let it be published. We will consider after that. Date will be fixed 1 or 2 days, at least 2 days in advance.
Extremely
Obliged,
grateful.
Obliged, your lordships.
Thank you. Yes.
Number 5.
Today appear for the
Affidavit of service.
There is a delay of 435 days, my lord, in preferring the application for review.
You are for the applicant.
Review applicant.
So you have to serve.
But we have already served the application. My learned friend is appeared.
You are opposing. State.
State GST.
State GST.
You are opposing. No. Let me understand whether you are opposing or not opposing. Let us understand. We will keep in mind when you come with an application under Section 5.
But
Kindly don't take me.
That was on a lighter note. Mr. Chakraborty, don't take
Lost
everything.
that experience I have.
Yes.
Only thing, my lord, they had filed a writ petition in between. After the division bench's order, they had filed a writ petition, which was withdrawn.
After the division bench
Let me tell you, Lordship, sir, what had happened. My lord, we had challenged, my lord, the jurisdiction of the Deputy Commissioner of State Tax to issue, my lord, the suspension of our, my lord, GST registration. Now, my lord, that was the subject matter of challenge in a writ petition before the learned single judge. The learned single judge dismissed the writ petition on the ground of delay. Now, my lord, we preferred an appeal, my lord, before the Honorable Division Bench. Now, my lord, the
preferred an appeal
before the Honorable Division Bench. The Honorable Division Bench, my lord, there, my lord, our contention was that the Commissioner of State Tax did not delegate the power to the Deputy Commissioner of State Tax, but and the Deputy Commissioner of State
so without jurisdiction.
Yes. And my lord, the Honorable Division Bench, my lord, remanded the matter to the authority. Before the authority, we raised this point that you do not have the jurisdiction to try it out. The authority, my lord, dealt with that jurisdiction point, saying that whether I am the appropriate authority or not, I cannot decide it myself, and proceeded to pass the order. My lord, that order, my lord, was challenged by us by way of filing a writ petition. In that writ petition, we once again took the point that, my lord, he does not have the jurisdiction, my lord, to suspend my or cancel my GST registration. Now, my lord, that matter,
GST registration was cancelled on what ground?
my lord, on the ground, my lord, non-payment of, my lord,
Non-filing of returns for 6
non-filing of
months.
returns, my lord, for some period within time.
More than 6 months.
More than 6 months. But my lord, our contention was that the Deputy Commissioner of State Tax did not have jurisdiction.
Yes, Mr. Chakraborty, why are you fighting for this?
My lord, I'm not fighting.
Let them
Kindly,
file.
my
Let
lord,
them file.
if the division bench has not passed an order, what my learned friend says, it doesn't go with the facts. My lord, kindly see the division bench's order.
Kindly see the
My lord,
division bench
my lord, in a division bench, my lord has passed so many orders on this issue. My lord, kindly see, he did not get an order from the division bench.
No, the division bench allowed my appeal. The division bench allowed my appeal, but my lord sent me to the authority.
He never raised the issue of jurisdiction.
Well,
But
that-
after 1.5 years, he is raising this.
But that
when
was
the deputy commissioner has already passed
that
an
was
order in
all along my challenge
2024.
before in my writ petition,
Kindly see the
all
order
along
of
my
division
challenge before the Honorable Division Bench. The learned single judge only said that you have come up before this court after 1 year and 7 months, so I cannot entertain your application. But that was the order before the subject matter of challenge before the Honorable Division Bench, and the Honorable Division Bench condoned the delay, but my lord sent me, my lord, before the authority. Before
Now he challenged. Kindly see the remand was to the deputy commissioner. Remand was to the deputy commissioner.
Of fresh consideration.
Yes, but now
But
he
fresh
challenges the jurisdiction.
No.
The deputy commissioner has already passed.
my lord,
an order. Now he
my
comes up
point
after 2 years.
my
challenging
point before the Honorable Single Bench as well as the Honorable Division Bench
So you are
was.
preferring a review against this order. What's wrong in this order?
But the wrong in this order, my contention before the Honorable Division Bench was what I wanted adjudication is whether the Deputy Commissioner of State Tax had the jurisdiction, my lord, to hear me out. My lord, the Honorable Division Bench, my lord, did not consider that and remanded me to the Deputy Commissioner of State Tax. The application for stay, I shall show to your lordships.
Sir, were you present at the time when the appeal was heard?
My lord, we were represented. My lord, I cannot, my lord.
You appeared?
No, my lord, I personally did not appear.
How do you know what submission was made?
My lord,
How do you know what submission was made? And this order was passed sometimes in the month of May 2024, and you have filed a review application with a delay of 440 days.
No, my lord, only thing
change
is
of advocates.
It's
We will impose heavy costs.
I have not taken the point of
So
change
this
of
was the
advocates.
argument. We cannot go into other points because
But
this
I
was
have
the
not
argument.
taken the point. But kindly as a look at one document.
The records of the court are sacrosanct.
But
So you cannot
kindly
improve upon by saying that yes, we said this
No,
thing, and that at a point of time after 440 days.
But assuming, my lord, this order was passed, my lord, in my presence, the matter was relegated to the authority. Assuming. But
Yes.
even if, my lord, the authority did not have jurisdiction, my lord, whether I am stopped. The authority never had jurisdiction. Authority has heard me.
But is this point before
But
the
that was all along my contention in my appeal.
Sir, you may have taken 10 points in your memorandum of appeal, but you have asked 1 or 2 points. That has been reflected in the order.
But that is exactly why, my lord, I am praying for
Now you
review
cannot
of it.
improve upon your case by
But I
saying,
am,
yes,
my lord,
yes,
I am not.
I have taken, there are other grounds.
My lord, the records will speak of that. It is their document. It is not my document.
What?
Kindly has a look at page 81.
Did you reply to the show cause?
Yes, my lord, I have
replied
replied
to the show cause.
Well, recorded in the signature.
But I have replied to the show cause.
No, but it's recorded in the order itself.
But I have replied to the show cause.
No, this order was appeal is set aside.
Paragraph
Matter
6
is remanded to the.
paragraph
My
6
lord,
of the
the
judgment.
honorable
But have
division
adjudicated
bench
the show
again
cause notice and
remanded
pass
me
it
back
without
to the.
affording. Look, if I correctly remember, these are the issues wherein the show cause notices, there is a tabular column which shows that whether personal hearing is necessary or not.
Absolutely, my lord. About
So
down.
there it has been mentioned as NA, and that has been adjudicated.
My lord,
So in those cases, I think this is one of
75
those
section-
cases where it has been said
75(4),
that
my lord.
show cause could
Infraction
not,
of seven-
yes, show cause could not have been adjudicated without giving in an opportunity of hearing. Pure and simple, that order of adjudication was set aside, remanding to give you an opportunity.
My lord, before that authority, my lord,
Now he has filed a
my lord,
petition
before that,
after.
my lord,
My lord, it is, the
lordship
matter
would-
does not
ভাই,
end there.
আমাকে একটু
Thereafter,
বলতে দাও,
you had filed a
আমাকে
writ
একটু বলতে
petition
দাও।
which was withdrawn unconditionally.
No,
Can you see the
that
order?
that was not the case. My lord, the honorable division bench, my lord, remanded me back to that authority. The authority, to that authority, who did not have the jurisdiction to hear me. So, my lord,
You cannot accept that, because if you had taken the point that the authorities did not have jurisdiction, this order should not have been passed. That would have been.
my lord, the
adjudicated.
contention was that you raised this point before the authority,
Where?
that you don't have jurisdiction.
Where it has been said.
But it has not been said, my lord, in terms of the order.
Don't you put something in the order which has not been. Ashun, the we are ওই এটা পাবে বোধহয় পেজটা হচ্ছে হয় 1000 কিংবা 11। Next matter. নেই they are not inclined to review আবার তার কি আছে এটা আবার কি
Well, I beg to appeal from the applicant. This is a violation of the order. My last order, passed on 2nd September 2025. I have been directed to serve copy of the contempt application upon the contemner. I have served. This is the affidavit of service, my lord.
contemner who appeared in the writ petition
My lord, when review application and contempt application was heard together, Supratim Dhar was
for the state
state. After date
what is the violation
violation, this is the field of the pond. Direction was issued upon the block land and land officer to remove the the construction made by the club, but partly done, and still, my lord, club exists there, my lord. Personally, BLO my lord, told that we have no force.
Who is the alleged contemner?
Block land and land reform officer.
Affidavit service filed in court today is service taken on record.
Yes.
Yes, next.
Madam, for the petitioner, my lord.
My lord, I am for the
Rapid
alleged
service.
contempt.
Yes.
But kindly come to page 30, my lord.
Page?
Page 30.
Page 30.
My lord. In this particular proceeding, my lord, the opposite parties were directed to serve copy. My lord, we kindly come to paragraph 14, last but 4 line. The concerned court is directed to furnish a soft copy of the investigation report to the applicant within a
That has
period.
not been furnished.
No.
Yes, it has been furnished.
No.
It
My
has
lord,
been
kindly come to last paragraph, page 15.
Page to the
Additional Solicitor General, Learned Additional Solicitor General, that the report is voluminous, running to more than 4,000 pages. Now, my lord, may kindly
Soft
come
copy they have.
No, the soft copy which they have supplied, I have annexed. That your lordship may be finding, I have annexed in my page.
You have annexed?
Page 48 to 99, 100. So these are the soft copy which they have supplied, and in court they have submitted that there are more than 4,000 copies.
Yes.
Now those copies are required. Those are forming part of my defense in the subsequent proceedings.
So Kundalia, what do you say?
In court itself, they have stated 4,000
Copies
pages.
Talking about all the copies that are with us, we have given them. Copies are they are talking about are sealed. There are some sealed pen drives that have been given to court. Now, as my lord knows, that submission is based on certain encryptions that are done, which are kept with the court. Now, we do not have copies of those documents. Now, even those documents.
Only one thing. He says you have only supplied the documents from page 48 to 99.
No.
If that is so, we can record that you have only supplied.
No, my instructions are there are more.
But you have not given them.
They have admitted in the.
No, there are more documents that have been given to them apart from these.
No.
That is from instruction, I'm saying.
We have printed all copies.
Running to how many pages?
Everything. That soft we have printed.
Everything we have given in soft copies.
Pages. Running to how many pages?
Immediately she can't recall, but she has given all the documents with regard to in soft copies. The only thing which upon instruction I'm saying are certain sealed
copies with a hash value.
Certain sealed copies with hash value which are there. Pen drive and a CD.
The documents which you
Other
have
documents
seen.
are all given.
There is a dispute that soft copies he says.
Is he?
Can you not give the hard copies of those documents?
Is he saying that we have not given anything other than this, other than page 48?
Yes.
No,
Madam
don't
says,
say.
No. He says from page 49 to which
48
page?
48 to 100.
48 to 100. Yes. 48 to 100 is accepting. Mr. Kundolia, from 48 to 100 he is accepting.
No, my lord, will kindly come to 48 once. 1, 2, 3, 4.
At page 30, they are stating before the,
My lord, these are the documents we have given, which is apparent from page 48. Now from 1 to 5.
These are the documents you have given.
Yes.
So
now from 1 to 5, serial number 1 to 5, this is the difficulty.
This cannot be these pages.
No, my lord. Before that, my lord, kindly see serial number 1 to 5. Just seize once.
Yes.
1 CFDML report dated 5th April. 1 sealed box attached with hard copy. They want that. CFDML report dated 5/7/22. 1 sealed packet attached with hard copy. CFDML report dated 15/12. 1 sealed packet attached with hard copy. CFDML report 1 sealed packet attached with hard copy. And CFDML report 1 sealed packet attached with hard copy. Now we have, just a minute, we have given the reports to them. But all the other data that was there in this in the original form.
Mr. Kundolia, if we go by the order, please see paragraph 14 and 15.
Yes, I've seen it.
So you have said that we will be giving soft copies because this is a voluminous document
Correct.
containing 4,000 pages.
Correct. Absolutely.
If you say so, it cannot be these documents.
No, my lord.
Either you give the.
No, I want to give. It's not that I'm shying away. I have to get an order from court for this. Because for the reasons that when these documents have been submitted before court, it has been submitted in a sealed envelope. And sealed envelope based on the lab certification. Now, the difficulty is even if we have to get it from court, to give a copy to him, that has to be done by the lab only. Subsequent lab certification.
Then, Mr. Kundolia, you have to explain by way of a report which documents you can give, which documents we cannot.
No,
we
these
cannot
five.
modify this order.
Only these five.
So no, we cannot modify this order.
I'm not seeking
Either
modification.
if we have to see paragraph 14 and 15.
Correct, my lord.
Paragraph 14 says soft copy, 15 says 4,000 pages.
No, my lord.
You wanted to supply these 4,000 pages.
I still want to give. I have working copies I can give. If my lord says that I can give, I may ought to give.
Mr. Kundolia, whatever you want to give, you give.
No, my lord.
We will not
My lord
be
is
modifying
my
any
lord,
order passed
my lord
by-
is probably not. I have not been able to explain. What happens is when these documents are submitted before the court, at that time there is a certification that has to be given. It's in original form that is kept with the court. Now to take copies, the copies that I have, the working copies I can give. But once those particular documents that have been submitted in court, I don't have a specific copy of
follow that.
Yes.
But we cannot explain and modify this order.
These are practical difficulty that I'm
practical
facing.
difficulty, Mr. Kundolia. These are the orders you say either you have complied with or you have not complied with. You have not filed any application for review or modification.
No, I have.
So
I have
so you have
complied
to-
with it.
So either
What I
he
can do,
says
what I can
soft
do, my
copies,
lord.
the entire documents were not given. Give the hard copies of the documents, then he will be saying
What
whatever
will be the hard
documents,
copies?
whether that satisfies or
Soft
not.
copy also you can give from the working copy. Huh?
Hard copy or soft copy.
Anything. The documents which are in sealed cover.
That I don't know. We don't know because this is the order. That was the direction. Because on the submission of the learned additional solicitor general, it says since it's 4,000 pages, we cannot give it. No other reservation was
Can I
made.
suggest only one thing? To make the whole thing, it's not that we are hiding these documents. It is in court. My suggestion would be if they apply before this court, we will give our consent for them to get this copy taken out from the court. And the procedure, my lord, is there in a Supreme Court judgment. In similar case, something has been passed. I had a copy, my lord. I have only one copy. he sees from paragraph 11. This will solve the issue.
But Mr. Kundolia, the difficulty is that we cannot, that will be amounting to modifying this order. In contempt jurisdiction, we cannot
That is
modify
the
this order.
difficulty I can
That's the
understand.
difficulty. Our hands are tied. It's a limited jurisdiction. How can we modify? Mr. Kundolia, because this was
My
on
lord,
the
kindly
basis of
seize this once, paragraph 11 once. এই আছে, এটা বার করে দেন। Judge, second judge appeal. একটা কপি এক্সট্রা করে আসেন কেন, একটা কপি
Yeah, let me take instruction with respect to those working.
Let me. Yes, suggest one more thing. My lord, give me 1 week time. Let me speak to the higher administration also, officers. If there is any possibility of getting the working copies also, if I can do that, I will definitely try to in the meantime. Otherwise, I will have to take the help of my lords with regard to this.
because only one thing what's troubling us is that you said that only objection was that since it is voluminous, more than 4,000 pages, we permitted you to give soft
Correct,
copies.
correct.
That was the only, no other objection was
Correct,
raised that this cannot be
correct,
given, that cannot be given.
At
It
that
was-
point of time, we also didn't have,
Yes.
we didn't also know.
So now we cannot modify this. Now, according to you, you have given soft copies. He is not denying that.
Yes.
But he says
Some
not-
of them have not then.
Yes, most of them, not some of them.
No,
He
five.
says,
Five
he
documents.
says few of them have been given, most of them not given. And you say, yes, most of them given, some
No.
not given.
He doesn't say, apart from these first five, all are given. He
This
doesn't
first
say.
five, yes, sir. Are you agreeing to that?
Well, what had happened?
Apart, tell us from 6 to 24, which you have not got, I will give you immediately. Within 2 days. From In fact, with regard to 1 to 5, the reports have been given to them.
Sir,
No, let us
Which
proceed
they have
from-
annexed here.
From 6 to 24, you can give it now.
Yes, we have given all to
6
them.
to 24, have you got this?
Those are annexed. Those are annexed.
Those are annexed.
Those are annexed.
So now it's trouble with regard to 1 to 5.
1 to 5.
My lord, may I clarify everything? What had happened? They have collected soft datas
Yes.
from several banks. My lord, those several datas also had evidence with respect to the bank giving information in mail. There were trails. Bank has specifically stated that there were no frauds. So my lord, these mails were very much required for us also, because when they are investigating agency, they are supposed to be investigating fair.
No,
So
I'm
my
not
lord, in
saying
that
you
form,
should
whatever
get,
they
you
have
must
collected,
get. I'm not
so
saying
they
you
have
should get.
collected the trail, email, whatever may
No,
be
see,
from the
please,
bank.
please see, these page numbers are given
My lord,
from item number 6 to item number 24. These page numbers are being mentioned.
my lord, those,
So have you got this?
those I have annexed. Those I have
So
annexed.
this you have got.
My lord.
So only with regard to 1 to 5 you have not got.
Yes.
But beside this, others are there. Can you come to page 49, my lord?
49.
Page 49.
Yes.
Kindly see the soft data they have collected. Your lordship is finding exhibit details.
That is there in those 1 to 5.
Your lordship is finding serial
That
number
is
1,
there
2,
within
3,
1 to
4.
5.
Yes.
1 to 5. No. This is going on. Can you come to page 50 then? These are the data they have collected.
है कि नहीं है?
Page 51 also.
Yes,
It is not that I am asking in hard copy. Let them give soft copy, my lord.
Yes, Mr. Kundalia,
So much
he
data
says
are
that
there. So
you have
much
given
data
this
are
one,
there.
but this has not been given.
Again, page
Give soft
51.
copies.
কোনগুলো বলছেন?
এই স্যার দেখুন মার্ক করেছে পেজ 51 16 জিবি 8 জিবি 64 জিবি এগুলো অনেক সিজ হয়েছে
ये
बैंक
सॉफ्ट कॉपी गुलो दिया है
सर ये सीज वाला तो वही सील्ड वाला है सर ये तो 14
He's saying the ones he's talking about are the ones of part of 1 to 5.
1 to 5.
सर there
May he,
no sorry
yes, yes.
that these are the part of 1 to 5. This is the first report dated whatsoever 5/4. This is 5/4. The second is 5/5.
Oh, what he's saying is, my lord sees page 49.
Yes.
And also reads it with page 48.
Yes.
Page 48 says CFDML report dated 5/4/2021.
Yes.
Now, my lord, kindly sees page 49.
Yes.
This is also 5th April 2021. This is the report.
And this is the CFDML.
This is the CFDML report. Now, what he is talking about is the sealed data that has been given.
This is the envelope mode.
The sealed data that has been given, that is what he wants. That is part of 1 to 5.
Even the extract of what is in the pen drive is page number 743.
My lord, will kindly see page 57.
Not up to page 54 details they have given.
Rich.
Sir, सबका दिया.
You see, if you appear before the trial court and make an application with regard to
We have
that, I
made.
think that will be.
We have made, and pursuant to this honorable court direction, that direction was given to us. We have made there. There also a specific prayer was there with respect to paragraph.
So
page
what
number
happened?
48.
What happened to that application?
Their order was passed. Thereafter, they have supplied this. Thereafter, they have supplied these 49 pages.
No, if there is non-compliance of that order, according to them, you take steps there.
No, honorable, this honorable court has given direction to make an application. That order is also. Number 47.
Please see the order. Once paragraph 14.
Page पर देना.
Yes, that application was filed.
So we directed the court also to supply the soft copies.
My lord, page 47 kindly come. There also direction was passed. They have there again they have admitted that they will be supplying. But
No.
same 48 pages, not 4,000
So
pages.
now it's before the learned trial judge.
My lord.
So if there is any violation, you want any copies, you can approach that court.
But we have approached there. Order was passed there.
Yes.
Kindly come to page 47 once.
If you are aggrieved by that order, or
No,
they
we
have not
agree
taken
by
steps pursuant to that order. Look, here we have directed you to make given liberty to you to make an application. If you file an application, the court was directed. So
My
the
lord.
court direction was passed upon the court.
My lord. That direction kindly, your lordship, kindly come to page 47 once.
So contempt doesn't lie on me. It is before the
No.
court. The direction
This
is on the
honorable court
court.
direction is still not complied. That is what I am submitting.
How? It is for the court.
Kindly see last paragraph during the courts of hearing.
We give you liberty to approach that court if that direction of the court, because the trial court has also directed.
My lord.
According to you, that direction has also not been complied with.
My lord.
So we give you liberty to approach that court if to give you liberty to make an application alleging that the direction has not been complied with. The court will
Yes,
act according.
that
to
is
our-
exactly what I
There
submitted
we have
at the very
twice
beginning.
file application. Thereafter order was passed. They have admitted that they will be supplying. They have supplied only 50
Please
pages.
consider one thing.
My lord.
The documents are in the custody of the court.
My lord. No, my lord, in respect of this, my lord, I will make submission. Whatever happened, whenever the investigating agency submitted charge sheet or complaint, they used to have 2 copies extra with them. Why I am saying so? If totally entire record is submitted in court, there is every chance, or there may have been probability once if record is.
No. Let us
So
keep
it
that
is
aside.
not that it is only one record they are saying.
We are not saying that it is only one copy,
My
but the
lord.
records are with the court.
Yes.
And there is a direction upon the court to file supply you the soft copies. If that is there,
records.
you are protected. So it's the best place where you can say, look, this is the order and this is the copy we have got. The other copies have not been provided.
And they are not giving me.
My lord, may I
They have
submit,
not
my lord?
given me.
The entire.
I think that's the.
The entire records have not been submitted in court. That is why the last direction at page 47, your lordship will be finding the honorable court has directed. The said application is disposed of with a direction to the learned to serve copy of the document as mentioned in the said application to A4.
Page 47.
Page 47, my lord, last paragraph.
Yes.
Kindly see. During the course of hearing, the
Yes.
learned PP submitted that they will supply soft copy of the documents as asked for in the said application to the A4. Accordingly, the said application under such and such is disposed of with the direction to the learned PP to serve soft copy of the document as mentioned in the said application to A4. Now, my lord, both order, the Honorable Court's order as well as the Court of Learned Trial Court's order, both are with respect to same documents, 4,000 pages, which they were supposed to supply, but they have supplied only 49 pages. Now, my lord, I am still before your lordship saying that the order which they have passed in before the learned Honorable High Court, there was they have admitted the 44,000 pages they will be supplying. It is still not supplied. They are saying that they are in position. They can supply, but my lord, they are not supplying. This is causing delay.
It is submitted.
Let them come with instruction. I
Again,
will
he's
also come with
going back
instruction.
to
my
the
lord.
same thing. Document, first the order was that they will file an application before the learned court. Court will make the documents given to, documents will be made available to them. Consequently, we have submitted the whole set of documents before the learned court. Now, his difficulty is, and my difficulty also, is that the sealed cover documents that we have given, those are not with us. That is with the court. So, court, in compliance of the High Court's order, can direct that from these documents, you kindly make copies and do
Please
the
kindly come to page 47.
47.
During the course of hearing, the learned public
Yes.
prosecutor submitted that they will supply soft copies of the documents as asked for in the said application.
A4.
A4. Where is A4?
Who is
Accused
A4?
for,
First of
accused
all,
for.
who is
My lord,
A4?
we are the petitioner, A4.
A4.
A4 has
So as
not even
asked for, so they
Yes.
have asked for some documents.
Yes.
So you will supply. It's the
Yes.
public prosecutor who
That has
said he
been
will
given.
supply.
That has been given. These are the documents he's saying.
Let
the
them come with
are the
instruction, my
documents. No, our instructions are very clear here.
No, but you have submitted that it was 4,000 pages.
No, I still say, might not be 4,000, but rough, close to,
Yes.
close to plus minus 4.
Yes, yes.
It might be more than 4,000 also. I still say that. I'm again saying I'm not shying away from these documents. Are the documents of the evidence has been placed before the learned court. It is lying with the learned court. The order of the High Court was that go before the learned court and get the documents. Now today my difficulty is the soft copies that are there before the learned court are something which are certified. Now for me to do that, to give those copies to them, I have to take the permission of the court.
Kundalia, did you take that plea in the court below? Show me.
Whatever documents that I have
No,
given.
these documents which cannot be supplied because the PP was directed to supply all those documents. Show me that you have taken this plea, that these are the certificates. We cannot produce
The
this.
certificates are annexed. The reports are annexed.
This
already.
is the some documents we cannot produce.
No.
You have not said before the court
we
also.
kindly see from page 49 onwards.
Mr. Kundalia, please take instructions. What are the other documents which you can supply? We are adjourning this because you have to either supply or because you have not taken that plea. What plea you are taking here? You have not taken that plea before the learned trial judge. That, no, these are lying in the envelope. This cannot be supplied. You have not taken that.
No, it can only lie with the learned court. It cannot be
taken that plea. Look, this we cannot supply. But the direction was upon the public prosecutor. He also kept quiet. All right, I will supply. So,
but in any case, my lord, this is not a case of contempt. My lord, kindly see. It can't be. If my lord sees the order, kindly sees the order once.
Mr.
I'll come on that.
Please take instructions. The learned advocate appearing for the
order had, he showed at page 47, is of another accused, not him. A4 is Pawan Kumar. Pawan Kumar Agarwal. The order was not passed on him, which is why this order was passed.
I will show next.
I'll come on the next one.
Deep level, let's say.